All rise.
The Kosovo Specialist Chambers is now in session.
Good afternoon, everyone, in and outside the courtroom. I think I've never seen this courtroom that full. I think it's a good sign. It means that the pandemic is finally getting to an end. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case CBC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Kresnici.
Thank you, Madam Court Officer. Now we'll kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor, please.
Good afternoon, Your Honour, and to all of those joining. For the Specialist Prosecutor's Office this afternoon are Alan Teager, Senior Prosecutor, Ward Ferdinandus, Head of Investigations Prosecutions, Nathan Quick, Associate Team Leader, Marlene Yaya Haga, Legal and Disclosure Officer, and I am Claire Lawson, Senior Prosecutor. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. May counsel introduce themselves and their team, starting with Mr. Kihu, please.
Yes, good afternoon, Your Honor. Good to see you again. Gregory Kehoe on behalf of Mr. Hashim Thaci. With me is Daskid Polaska, counsel, Jonathan Greenblatt, as well as to my right is Sophie Megnon and Bonnie Johnson.
Thank you, Mr. Kihu. Now I turn to Mr. Emerson, please. Microphone, please.
To the right. To the right. It says right here.
Sorry, wrong button. I do apologise. Good afternoon to Your Honour and to everyone inside and outside the courtroom. My name is Ben Emerson. I appear on behalf of Kadri Veseli, assisted today in court by co-counsel Mazani O'Reilly and by Pascal Longley, our legal assistant, and remotely by Mr. Andrew Strong, co-counsel.
Thank you, Mr. Emerson. Now I turn to Mr. Roberts, please.
Thank you, Your Honour. Jeff Roberts on behalf of Mr. Recep Selimi, together with Ms. Natasha Rizhenko, our case manager. Thank you.
Thank you, Mr. Roberts. And now I turn to, is it Mr. Langendra or Mr. Ellis? I see Mr. Ellis is standing.
Thank you, Your Honour. Good afternoon to you and to everyone in the courtroom. I'm Aidan Ellis for Jakub Kresnici. I'm assisted in the courtroom by Victor Baishu, our co-counsel, and behind me sits Kalina Tsetkova, our case manager. And by video link today, we have lead counsel Venkateswari Alagendra and also mentor Bachiri.
Thank you very much, Mr. Ellis. Now, let me turn to the counsel for victims, but before, for the record, I note that Mr. Thaci, Mr. Veseli, Mr. Selimi, and Mr. Kresnici are not physically present in the courtroom, but attend this hearing via video conference. Mr. Laws, please.
Good afternoon, Your Honour, and to everyone joining us today. I'm Simon Laws, assigned counsel for the victims.
Thank you, Mr. Laws. And now I turn to the registry, please.
Good afternoon, Your Honour. My name is Ralph Roach, Judicial Services Division in the Registry. Thank you.
Thank you very much, Mr. Roach. And for the record, I'm Nicholas Guillou, pre-trial judge for this case. On 18 October 2021, I scheduled this 8th status conference. I asked the parties to provide written submissions if they so wished. On 27 2021, the SPO and the defense for Mr. Selimi and Mr. Kresnici filed their written observations. I thank these parties for their written submissions. The purpose of our hearing today is to review the status of the case and to discuss the topics in our agenda, specifically disclosure, translations, SPO investigations, and defense investigations. I will invite the parties to present their views in a concise fashion about each item. And as usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information, so we can go into private or closed session. Let us start with the first topic that was listed in the scheduling order, which is disclosure. As I did in previous status conference, I will give the floor to the parties on the disclosure of each category of evidentiary material separately, starting with the Rule 1021B material, which is the evidentiary material the SPO intends to use at trial. Then the Rule 1023 material, which is the material relevant to the case as listed by the SPO. Then the Rule 1023 material, which is the exculpatory material. And finally, the Rule 107 material, which is protected material for which the consent of the provider is requested. I inform the parties that for the discussion on the Rule 1021B material, I will first give them the floor on the disclosure deadlines, and in a second row of discussion, we will discuss the Selimi defense request for further linkage of evidentiary material. So this will be for a separate round of discussion. Let us start with the disclosure of Rule 102B material, and especially the deadlines. At the last status conference, I issued an oral order concerning the SPO's deadline related to a number of Rule 1021B material. I extended the deadline to 1st November 2021 for the statements of 3 international witnesses with pending Rule 107 clearances, the report of 3 expert witnesses on forensic matters, and the materials subject to request for protective measures. I note that since the last status conference, the SPO has disclosed an additional package of Rule 1021B material and 2 packages containing translations of such material, but there are still outstanding materials to be disclosed. I inform the parties that I will issue a decision on the 11th request for protective measures next week, after the current 1 November deadline for the disclosure of the Rule 1021B material. The 12th request for protective measures, the decision of the 12th request for protective measures will be issued thereafter. I would like to hear from the parties what progress has been made in the disclosure of Rule 1021B material. In particular, I would like the SPO to indicate how much of such material remains to be disclosed, and what are the outstanding Rule 1021B materials to be disclosed. I note that the SPO seeks a further extension of the current deadline to 31st January 2022 for the completion of the disclosure and translation of remaining 1021B material. I invite the SPO to give details on the expected timeline for the disclosure of remaining 1021B material and for the finalization of translations of this material. And I also invite the SPO to indicate whether further protective measure requests in respect of Rule 1021B material will be necessary in order to complete disclosure of such material. Madam Prosecutor, you have the floor.
Thank you very much, Your Honour. As indicated in our written submissions, in terms of volume of new materials, we're certainly nearing completion of Rule 1021B items. Since the last status conference, there have been 3 packages of Rule 1021B materials disclosed. That is packages 87, 103, and 105. In terms of what has been done, the reports of the 3 expert witnesses have been obtained, and the relevant protective measures application has been filed. Clearances have been obtained in respect of the statements and associated exhibits of the 3 international witnesses, and those materials have been disclosed, with the exception of one document, which I will come back to, and further materials relating to witnesses which had been the subject of variation requests before third-party institutions have been received and disclosed. We do not anticipate releasing any further Rule 102.1b disclosure packages before the 1st of November. We believe that all of the cleared materials in our possession have been disclosed. We also do not anticipate a further protective measures motion in relation to Rule 102.1b material at this time. Nevertheless, there are a small number of items for which clearance or variation remain pending. Those items are specified at paragraph 12 of our written submissions, and I will also go through them now. There is one associated exhibit of an international witness for which clearance was denied, and we are therefore conducting further discussions with the provider in relation to that one item. There are 2 witnesses in respect of which variation decisions are awaited for certain of their materials. That is, their prior evidence before a third-party institution. All other materials relating to those 2 witnesses have been disclosed. And finally, we are awaiting receipt of lesser redacted or unredacted versions of previously disclosed materials in relation to 3 witnesses. That is the extent of Rule 102.1b materials that are outstanding and for which we request an extension. Each of those items are subject to variation or clearance decisions, and therefore we're not in a position to specify exactly when those decisions would be made and when the materials would be received, but we would, of course, disclose them as soon as that occurred. We have also made every effort to expedite outstanding translations of Rule 102.1b materials. As I indicated at the last status conference, the SPO has prioritized the translation of these materials, and we've constantly sought to maximize available translation resources. Further steps were taken since the last status conference to try and ensure maximum capacity and efficiency in that process. The steps are outlined in our written submissions, and while they generated some positive results, the forecast has not significantly improved. We are processing and disclosing translations on a rolling basis, and we will continue to do so. Since the last status conference, 4 packages of translations have been disclosed, most recently in Disclosure Package 109. Those amounted to 1,669 translation items. However, as previously estimated, given the volume and nature of the materials, some of which are handwritten documents, it is anticipated that translation of Rule 102.1b materials will continue to December, to the end of this year. A significant number of the translated items then do also require redaction before they can be disclosed, and that is a time-consuming exercise involving multi-level review and the replication of redactions from the original language into the translation. It's a task which again involves the assistance of language staff and therefore draws on the same small, limited pool of people. In order to enable this step to occur, we have identified the 31st of January 2022 as the date upon which disclosure of translations of Rule 102.1b materials is anticipated to be completed. And we have requested an extension of deadline for disclosure of translations to that date. However, we do emphasize that translations would continue to be disclosed on a rolling basis in the interim before that as they are available. the specific figures were in the written submissions, but I'm happy to repeat them here. I understand that we're going to return to the specific points made in the Salimi defence written submissions later, so I won't address them now. However, there is one point I would like to make, and that does go to the deadlines. The Salimi defence misrepresents the disclosure framework applicable before this court. Nowhere in the law or the rules is it required that the deadline for Rule 102.1b disclosure be in advance of filing of the pretrial brief. What is required is that Rule 102.1b materials be disclosed in accordance with the calendar established by the pretrial judge and at least 30 days before the opening of the case. It's the practice at certain other courts which apply similar pretrial frameworks for the deadline for disclosure of material to be relied upon by the prosecution and the deadline for filing of the pretrial brief to be the exact same date, and for that date to be 3 months prior to the commencement of trial. Therefore, by contrast, the regime of deadlines being applied by Your Honour in this case, whereby the defence has received the vast majority of Rule 102.1b disclosure many months in advance, is significantly more favourable to the accused than that applied elsewhere, and indeed more favourable than what is required by the rules. To try and cast this advantageous disclosure schedule as prejudicial or as reflecting delay is misleading, and the Salimi defence submissions at paragraph 8 of their filing are simply inaccurate. Thank you.
Thank you, Madam Prosecutor. Let me turn to the defense. Mr. Kihu, please.
Yes, Your Honor. I'm going to address some of the comments made by the prosecutor, certainly with regard to maximum efficiency and favorability to the accused, which we will address. But at this point, if I could just see our first speaking aspect on the 102.1b to counsel for Mr. Salemi, if he can just go first, if we can, and then I will follow after him. Okay, Mr. Roberts? With the court's permission.
Mr. Emerson, do you agree?
Absolutely.
Then I give the floor to Mr. Roberts, please.
Thank you, Your Honour. I see I've been promoted. I'll be very brief because I have set out our position in general on the 102.1b disclosure. In general terms, there's not much to add. The one thing I would note on this particular issue, obviously we've been referred to, or our submissions have been referred to as misleading and misrepresenting the state of the legal framework for 102.1b disclosure. I would note that in your original decision, your framework decision on disclosure back on, I believe, the 23rd of November 2020, you required the prosecution to have disclosed all the Rule 102.1b disclosure by the 31st of May of this year, if I'm not wrong. Now, we're coming up for 6 months ago, I believe, that should have been completed. Obviously, by the time they ultimately do so, that will be almost 8 months. Therefore, twice as long as you originally ordered. Now, I note, obviously, that they've requested extensions. Every time we come here for a status conference, it's like Groundhog Day. They ask for an extension. They seem to get an extension. We move forward. Nothing seems to really materialize or actually a specific deadline that they have to comply with. And so we're stuck in the situation where we are moving forward, but very, very slowly. And, Your Honour, I'm not a runner. I despise running generally, but it does feel that we're running and the finish line is getting further and further away. Every time we get close to it, the deadline just disappears off into the distance. So from my side, I believe, as I said, without getting into the specifics of Rule 102.1b and the specifics of what we're asking the prosecution to do in legal workflow, which I'll deal with later, I just feel we've not actually moved the dial forward at all. We're still stuck in the same situation. It's now the 31st of January next year before this will be completed, and we've still got, obviously, issues of the pretrial brief and everything else. So in terms of whether this is an advantageous disclosure process, I personally would take issue with that word. An advantageous disclosure process would have been one where the prosecution stuck with their original deadline, disclosed all of these materials 6 months ago as they were originally ordered, and we actually would have a much better idea of what their case would be. But apart from the submissions I've already set out in writing on 1021B, I have nothing further to add. Thank you.
Thank you, Mr. Roberts. Mr. Kihu, please.
Yes, Your Honor, just a couple of points. It's shocking to me that the prosecution stands up there at this point, and I'm sure Your Honor is frustrated with the level and the efficiency coming from the Office of the Prosecutor, given the fact that our clients were arrested and charged back in November of last year, and yet we're still talking about this, and they're talking to you, Your Honor, and asking for more time. Yet they say they're working for maximum capacity or efficiency, or come up with a regime that's more favorable to the accused? It's ludicrous. Let's look exactly what went on. Counsel just noted that the deadline initially was the 31st of May. I understand, Judge, that you gave some ordered extensions to that, but it was the 31st of May. But what's happened? Since our last status conference, we received 1,732 documents. We got 217 last night. That's 13% of the total production of this case, with our clients sitting in jail since last November. I mean, when, as Mr. Roberts said, when will they make an end to this? I mean, how can anybody in heaven's name say that they're operating at maximum capacity or doing anything favorable to the accused while these documents keep coming across the transom and all of these clients remain in jail? When do the scales tip to the point where this is just too much? Your Honor gives an order, and frankly, the prosecution doesn't comply with it. And now they're asking to kick it out yet till the 31st of January. The 31st of January. That's for 760 translations into English and over 1,000 translations into Albanian. Almost 1,700 documents to be translated. They wanted to go to trial last year or sometime earlier this year. And they come in here and they say, oh, we need to go to January 31st to get all this stuff translated. My client sits in jail and he is entitled to have these documents and assist in the defense. And the fact of the matter is, Judge, and I know I'm preaching to you, you understand this, he can't do it if he doesn't have the language, in the documents in his own language. You know, we get all this information, I mean, on their disclosure. And I know we're going to get to the witness list, but there are 327 witnesses on their list, and we have 122 where there's no identification in the redactions. You might as well just be talking to that wall because they're incomprehensible. 122. So what is this going to look like 30 days before trial? We're going to have 122 or something close to that pieces of information on witnesses to show up on our doorstep? Yet the prosecution is saying that this disclosure regime is somehow favorable to these 4 men who are sitting in jail? That's just ludicrous, Judge. It's ludicrous. There has to be, they decided to indict these 4 gentlemen. There has to be some line in the sand. Because it's not 31st January of 2022. That's when we're first going to get them. And I suspect that before 31 January 2022, we're going to get another request for extension. And we're going to kick it out yet further. And we're down the line into March, for instance. Suffice it to say, Judge, that there is a lot of disclosure that we know that they haven't disclosed. Heavens, there is 8 witnesses on their witness list where we haven't no 1021B information at all. There are 8 of them. We're looking through them, trying to find out if we know anything about any of these people. There's nothing. So I assume this is going to be part of some of these disclosures. But this continued extension, Judge, is prejudicial to our clients, to my client. And to stand up here and to say that this disclosure regime is favorable to the accused is a specious argument, should be rejected. We ask, Your Honor, to ask the government, tell the prosecution to toe the line with the court's orders and comply with the court's orders like everybody else in this courtroom is required to do. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honour, I have some general comments to make about the witness list that has now this week been served, but I'll reserve those until the appropriate moment of the agenda. May I just say this for the purposes of the first item, and it's going to hover over everything I think that follows, is that there is an elephant in the room, something that's not on your agenda, but which ought to be driving every single one of your decisions and ought to have been effectively the subject of a guiding principle for the prosecution. Mr. Kehoe has already stressed it in very clear terms, which is that the prosecution made a decision to arrest these men a year ago, and it's against the fact that you've remanded them in custody for a whole year that some of these issues now have to be decided. So when the prosecution says, as it said in its most recent submission on 1021B for this status conference, that it is substantially on track, I'm driven to recall the submission that was made on the, I think it was the 21st, the July status conference, 21st of July, 2 days in front of the 23rd of July. So 2 days before the deadline was due to expire for the foreclosure of this material, the SPO put a submission into the court saying that it was substantially on track to meet that deadline. 2 days before the 23rd of July, it claimed to be substantially on track. Now, with all due respect, that is a lie. That was a lie. And so when the prosecution writes in its submissions yesterday, oh, we're substantially on track, you've no reason, any of us, to believe a word. The prosecution has from the beginning, let's put this as diplomatically as possible, has from the beginning had an extremely casual relationship with the truth. They lied to you at the beginning when resisting the applications that were made for provisional release pending trial, and persuaded you to keep these men in custody, in part on the basis that although we said the trial couldn't possibly begin realistically before the end of this year, that's now, they were claiming that they could be ready for trial in June of this year. That was a lie. And it was a lie that must have influenced your decision, because you referred to it, it was referred to repeatedly in argument. And not only was that a lie, we were accused of misleading you by saying experience shows that this date is completely unrealistic. So not only do they lie, but they are prepared to entirely falsely accuse the other side of lying. And I'll give you another example of that later on in my submissions. But we're left in this situation where, as Mr. Rogers says, maybe they will, maybe they won't. But at the end of the day, every single tick of the clock, every single second of the clock now, whilst these men have been in custody, should be weighing very heavily on your Honour's thinking. You should be thinking, after a year, the prosecution need to really overwhelmingly persuade me that I can carry on, even for the next 24 hours, keeping these men in custody. Because otherwise this whole institution is shown up to be a disgrace. It's shown up to be an institution in which the prosecution is free to arrest people when they don't know what its case is. It's free to lie to the court and get away with it repeatedly. And every time it happens, with all respect, you listen patiently to me saying this, but you never say anything in response in any of the rulings, and you never require an explanation or an apology from the other side. And yet the world is watching, and we're in a situation where the court is beginning to look extremely badly managed to the detriment of individual defendants who are being held in custody. After that the 21st of July, they lie and say we're substantially on track for the 23rd. Since that 23rd July deadline, by which time defendants had been in custody, 9 months? Since that deadline, overall, the SPO has disclosed 10,039 items, consisting of 112,142 pages of evidence that the SPO intends to rely on at trial. Of all the evidence they now say they intend to rely on at trial, 80% has been disclosed since they lied to you on the 21st of July and said they were substantially ready for the 23rd. 80% of their case, which means that the first 9 months of custody was itself a lie. It was based on a lie about their readiness for trial. It was based on a lie about their ability to disclose. And I don't know about you sitting as a judge, but if I was a judge being lied to by the prosecution in this way, I would be beginning to lose my patience. And certainly I would be looking in a very different light to the continued protestations that these 4 men should languish in custody indefinitely while this prosecution continues to flail about with no focus and no organisation, and to continue a process where they deliberately structured it so the men were in custody for a year before they even disclosed their case. So we can't even start investigating until the end of January. That's when we're going to know what their case is. And I've got something to say about that as well, if I may, and I'll touch on it now. The foundation documents of this tribunal make it completely clear that it was set up in order to try the allegations that were described within the 4 corners of the report prepared, it was a political report, a pseudo-investigation by a politician called Dick Marty, a Swiss senator answerable to the Council of Europe, who wrote a report which included the most lurid and frankly absurd allegations that the Kosovo Liberation Army engaged.
Mr. Emerson,
No, I'm going to carry on if I may.
We are talking about the Rule 102.1b.
We are. And
I think this has nothing to do with the Rule 102.1b.
It absolutely does, I'm afraid. It absolutely
Then
does.
go quickly to the point.
Well, I'll go to the point in the time that it takes to develop it. I mean, with the greatest of respect, this is a two-way process. As I've said to you a moment ago, most judges in your situation would have lost patience with the prosecution. Please don't lose patience with the defence, because it's not us you should be losing patience with. So would you please give me a moment or two to elaborate my point? The institution was set up to examine those ludicrous allegations of organ trafficking. Now, we know those allegations were false, and we know that they were made up by witnesses who had been put forward by the Serbian intelligence service. We know that because it was proved as a fact in the Haradinaj retrial at the ICTY.
Mr. Emerson,
no, I'm not going to stop.
That has strictly nothing to do with what we're debating now. It absolutely
does, if you will listen to me.
We're talking about the disclosure deadline for Rule 102.1b material.
I know we are.
What you just mentioned was perfectly to the point, and I really hear you, but here, it has nothing to do with our agenda.
That's because you haven't the patience to listen to why I say it has.
I think I have the patience to listen to all the parties.
Please be
but
patient.
Please, here you're talking about...
We're wasting time now. I'm going to carry on until I'm finished. So we're wasting time now.
Then I can stop you. Thank you very much. Then please go to the point. I will hear you as much as you want, as long as you are first in the agenda, and second, you are relatively concise. Thank you.
I am in the agenda. I'm trying to be relatively concise. Every time you interrupt me, it slows me down. So would you kindly be patient and listen to what I have to say? That was the basis on which this tribunal was set up, and it's its foundational principle. It came as no surprise to anybody who knows anything about the conflict that the prosecution found absolutely no evidence whatsoever to support that central allegation. In other words, the foundation for the establishment of this tribunal was based on a lie. That much we know, all right? But what has happened since then is that the prosecution has now, this week, and this is why I'm getting to the point, so perhaps you didn't jump the gun, you perhaps listened to the reason it's relevant, this week...
Please, I would appreciate if you wouldn't criticize the bench like you do.
Well, I would appreciate if you didn't criticize counsel like you do.
I'm not criticizing you, I'm just telling that you have to stick to the agenda, that's all.
I am sticking to the agenda.
So please, if you avoid talking to the other parties or myself like this...
I will have a chance to explain why it's relevant to the agenda. I'm not going to be closed down, so we can carry on.
That's not my point, Mr. Emerson.
Well,
I'm just asking you to be polite in this courtroom.
I am being polite.
That's the only thing. I don't think you are.
Well, I'm sorry.
I don't think in any courtroom you would be let talk like that, whether it would be in the United Kingdom or any other international court. So please, focus on the point.
I am focused.
And I'm going to listen to you.
Well, so I don't understand why you think it's rude of me to indicate to you that I intend to explain to you why this is relevant. And I must say, as I said to you before, impatience is being directed in the wrong direction. Right? That much is, I don't think that's rude either, when you look at the truth of what's happened here. But the point I want to make is that we, this week, received the summary of the evidence, that's to say the prosecution's witness list plus summaries, of all the evidence that they intend to call. And as I said, it came as no surprise to anybody that the foundational allegation of the tribunal was a load of nonsense. What did come as a surprise, and it's become apparent as this process of disclosure has been ongoing, and was crystallized with the disclosure of the witness statements that the prosecution intends to rely on this week, is that there is no allegation of participation, incitement, instigation, or aiding and abetting any criminal act by Mr. Vasili. What becomes clear when you read the material that they have served is that it is the joint criminal enterprise they are alleging is itself the Kosovo Liberation Army, the existence of that group. And why does that matter? It matters because very recently, within a week of the last status conference, at the opening of the Mustafa trial, the prosecutor, Mr. Smith, said this: "The SPO does not levy accusations against the KLA or against the war it fought for Kosovo's independence. It is neither the job nor the desire of the SPO or myself to do so." And yet that is what we are here faced with now. There is no way of reading the evidence against Mr. Vasili or the others other than to say that what the prosecution is now scrabbling to try and do is to create a case that the Kosovo Liberation Army was a criminal enterprise. Now, this becomes very important to all of the issues on your agenda. It becomes very important to all of the issues on your agenda because if you start from the proposition that that is what they're setting out to prove, that's why we have a list of 327 witnesses. And 327 witnesses, of whom all but 50 or so are viva voce, that spells out a 3.5-year trial. 3.5 years. That's what, and you'll remember when it came to the very beginning of this case, I gave you some estimates about how long the pre-trial period would be, based upon experience from other courts. That's when the prosecution made their grandiose suggestion that this court was different, it would never fall into the same delays, and we're now worse than we were predicted at the time. So we have to accept that the prosecution is proposing a 3.5-year trial in order to try to persuade a court that the KLA was a criminal enterprise in itself. And these men have been plucked not because they did anything, but because they were successful politicians or otherwise prominent people who would just do for the purpose of sample defendants. I'm saying this with the benefit of the evidence that's been disclosed. Now, the prosecution is obviously struggling to draft its pre-trial brief because it's somehow got to make something out of nothing. It's somehow got to create a case against these 4 men out of nothing. So it's given itself the furthest possible date in order to be able to say, oh, we got it in 2021, the 17th of December, the day before the institutions closed for the holidays, totally no use to the defence until the end of January. But in order to meet some internal or external projected deadline, the artificial end date of the 17th of December has been given. I asked you to order the 31st of October. Not only did I not get a ruling in my favour, but I didn't get a ruling at all. I therefore put it in writing and asked you again, no response. Right? So we're here today with the prosecution saying they'd like until the 17th of December to try and come up with something out of this morass of material that they've served, indiscriminate morass of material. I know, because I've cross-examined some of the witnesses in other cases, these people have nothing whatever to do with their minor little incidents in far-flung places, people being kicked in the head. They're on the list. Nothing to do with any of these defendants. This is an absolutely chaotic, indiscriminate dump in a frantic panic to try and justify the fact that they arrested these men before they had a case against them. And however it was spun to you at the beginning to justify the arresting of these men, the fact that the prosecution has had a year and still can't state its case is a disgrace. But it's worse than that, because they're now saying, well, they'll do the pre-trial brief by the 17th, but what we won't be able to do is to give either a final disclosure of the 103 material that's being relied upon, or, and critically, the Rule 109 requirements. Now, Rule 109 requires the prosecution to categorise the information it's dumped on the defence in accordance with the charges on the indictment, with specific reference to the underlying crimes, the contextual elements of the crimes, the alleged conduct of the accused, or where applicable, evidence to be presented. Why can't they do that now? Answer, because they don't know. They haven't made it up yet. There's been no guiding mind behind this. If they was, they could do this chart jointly with the pre-trial brief. If the pre-trial brief was sufficiently particularised and cross-referenced, if they even knew what their case was, there would be no reason for them to be asking you till the end of January to make the connections between the evidence and the charges. So what we're going to expect on the 17th of December is another load of meaningless fluff of the sort that was put before you to justify their arrests, without any linkage, despite the year that's passed, between the actual evidence and the charges that these men face. Now, there can only be one inference from, if you look at the whole picture, they're arrested a year ago. The arrest is announced 6 months before that of Mr. Vasili and Mr. Thaci for reasons that have no relevance, but make it clear that a decision had been taken to arrest them even before the prosecution had begun to sift its evidence. Why? Because they're prominent politicians. They'll do. they'll do for the purposes of symbolising the KLA, which is being accused. Now, you know, you're right to say international courtroom, but this is a courtroom where the audience is not sitting in the public gallery. The audience is the Balkan area, and in particular the people of Kosovo, because you're a Kosovo court and they want to see that you're doing justice in their name. And they all know, everybody who knows anything about this conflict knows, that there is absolutely no equivalence whatsoever between the genocidal policy of the Milosevic regime to move into and across Kosovo and drive every Albanian Kosovar over the borders into Macedonia, into Montenegro, and into Albania. And on the other side, there was a people's resistance which grew gradually and with very little organisation in an effort to try and put a stop to that. But what we also know is that the ICTY had jurisdiction over Kosovo which was not specific to one group or ethnicity like this tribunal is. It tried the Serbian war criminals and it tried alleged Kosovar Albanian war criminals. And all of the Serbian war criminals were convicted of involvement in a conspiracy to commit crimes against humanity in order to ethnically cleanse the country by committing crimes against humanity village by village in a horseshoe movement to drive the entire population over the border. And all of the Albanian defendants were either acquitted or in one or two cases convicted of very minor offences. Same judges, same tribunal. But the reason why the result was different is because the truth was different. This was a group of individual farmers and others doing what they could to defend themselves. This mono-ethnic tribunal set up, despite the fact that there had been a fair trial of both sides, only to focus on the KLA, now comes to the point where we're a year in custody, and it's perfectly obvious to any objective observer that the prosecution is still flailing about with no idea what its case is. Now, I'm saying the elephant in the room is that these men are in custody, as I say, and I'm sorry this has taken a little time to explain, but it is all relevant to that. It's all relevant to the fact that the assumption underlying the prosecution is no more than that there's some sort of equivalence between the Serbs and the KLA. And that since no KLA people got convicted at the ICTY, it's justified to try and go again. And they made the decision to choose these defendants when they had no idea what the case against them was. They just picked them out of the air on the basis that they would do.
Thank you, Mr. Emerson. I will give the floor to Mr. Ellis, please.
Your Honour, thank you. I want to use my time to deal just with one specific example in relation specifically to the Rule 102 1B material. And I do that because it's an example that goes to support the general point being made that this all must be tied in with the length of time Mr. Krasniqi and the others have been kept in detention. Before I do that, Your Honour, I notice even as I sit here in the courtroom, Disclosure Package 109 has just been released to us. That following on from 3 disclosure packages yesterday, and I think 1 disclosure package the day before. If one were to plot the dates of disclosure packages against the dates when Your Honour fixes status conferences, I am confident that you would see a spike in activity the day before, and in many cases on the day of the status conference, almost as if there's a rush to get things out for Your Honour on that day. But the specific point I wanted to deal with is the translation of statements into Albanian. Ms. Lawson for the prosecution, didn't read out the statistics, but I think perhaps I will, because it's paragraph 17 of the prosecution's submissions. There are 1,400 Rule 102 1B statements. Of those, Albanian translations of 1,000 statements have yet to be disclosed to the defence. So as Mr. Krasniqi sits there in detention, as he has for 1 year, he is able to read less than 30% of the statements said to be against him. Now, is this a new issue? Is it something surprising? Of course it isn't, Your Honour. In their submissions to you on the first status conference, on the 13th of November 2020, filing 76, the prosecution had this to say: the SPO will provide Albanian versions of the statements of all witnesses it intends to rely upon at trial and intends to the maximum extent possible to provide these translations within the same deadlines requested above for disclosure of English materials. At that point, Your Honour, the deadline that they were talking about was the 31st of May, which of course has gone and gone by months. But they knew at the outset of the case that they were required to provide these statements in Albanian so that Mr. Krasniqi can read them. And I'm not asking for this for fun. I'm asking for it because taking my client's instructions on the statements against him are where my investigations need to start so that he can guide me on them. Fast forward almost a year, what are we, 11 and a half months to the submissions for today, and the prosecution say at paragraph 13, the translation of Rule 1021B materials in this case has been prioritised for several months. Several months. Mr. Krasniqi's been in detention for almost a year. What was happening before these statements were prioritised? It is in my submission simply not acceptable, and this goes in support of the general contention made by others, to keep these men in detention for this period of time when disclosure is not being dealt with efficiently, Your Honour.
Thank you, Mr. Ellis. Let me turn to the SPO in a concise fashion, please. And before you take the floor, I hope that we can continue this hearing without tension and aggressivity between the parties. Thank you. Ms. Lawson.
Thank you, Your Honour. To be clear, the date for which Rule 1021B disclosure was due was the 31st of July 2021, not the 31st of May. The July date was set not as a result of a prosecution request, but as a result of defence requests for additional subcategorisation, a request that was made in particular by the Salimi defence. The timing of disclosure packages are related to when materials are received, cleared, and processed. As the defence are aware, the SPO currently has a disclosure deadline of the 1st of November, and naturally we have therefore made every effort to receive and disclose items before that date. Consequently, there have been disclosure packages released this week. Disclosure Package 109, which has just been released, is a package containing translations, and that is in line with our commitment to disclose translations on a rolling basis as soon as they are available. With respect to the Thaci defence submissions, first, they have mischaracterised the submissions that I previously made. My comments were specifically in relation to the schedule of Rule 1021B disclosure relative to the filing of the pretrial brief. That is what the Salimi defence inaccurately based their written submissions around, and that is what I was responding to. In terms of the volume of materials which have recently been disclosed, the material that was disclosed since the status conference on the 21st of July was, in the vast majority, disclosed in the immediate weeks following that status conference. That is, in the first weeks of August. The timing of those disclosures, occurring slightly after the 31st of July, was the result of very severe technical issues, which resulted in legal workflow being unavailable for disclosure purposes, and of which we advised the parties at the time. Similarly, in terms of new Rule 1021B materials, The figure that has been disclosed since the last status conference is 187 items, not thousands of items. Protective measures are being applied where they are found objectively justifiable following individualized assessments. There are 203 witnesses in this case without any delayed disclosure and whose evidence the defense has received. The identities of a further 21 witnesses will be disclosed together with the submission of Rule 95.4 material. As for detention, detention is subject to separate, ongoing litigation. The legal framework provides a mechanism for very regular review of detention with an automatic right of appeal, and the continuation of detention is therefore considered on its merits. At this time, and based on the last review, including by the Court of Appeals, circumstances justifying detention have been found to continue to exist, and future reviews will continue to be litigated and considered on their merits on the circumstances that exist at the relevant time. As to the scope of this case, this is a case against 4 individuals. It is about the individual criminal responsibility of the 4 named accused. Relatedly, for the Vaselli defense to describe the mistreatment and abuse of victims in this case as minor little instances is insulting and it's gravely inappropriate.
It's also not what I said. I said some instances were.
Please, Mr. Emerson, you will have the opportunity to respond after.
The Vaselli defense has also taken a sudden interest in Rule 109. I would like to point out that all of the Rule 102.1b material has already been subcategorized through legal workflow in greater detail than will be done in the chart that was mentioned by Vaselli Defense Counsel. And we can come back to the chart at the relevant agenda item. As Your Honour rightly noted, the majority of the Vaselli Defense Counsel's submissions had nothing to do with the agenda item in question. However, there is one point that I would like to address, and that is the manner in which lead counsel for the Vaselli defense has just made his submissions. They are again throwing allegations of dishonesty. It is easy to make wild allegations if you ignore or misstate the underlying facts. The SPO did not say in our submission this week that we are, quote, substantially on track in Rule 102.1b disclosure. I'm not sure what Vaselli Defense Counsel is quoting from, but it is not our submissions of this week. It may well have been submissions made earlier in the year. The fact is that the record in this case is replete with examples of the Vaselli defense making factually inaccurate assertions and persisting with them orally or in writing, even after such inaccuracy has been brought to their attention. That is willful misrepresentation. Perhaps the submissions are just being framed to try and create media soundbites. But every person familiar with the proceedings knows that on a frequent basis, what lead counsel for Mr. Vaselli is saying is not true. To have the parties spend their time here in this courtroom exchanging hyperbolic jibes at each other and failing to conduct themselves with the respect and decorum appropriate to a courtroom does no service to justice or to the victims of the crimes. It does no service to the accused. The manner in which Vaselli Defense Counsel has just addressed the court is entirely unacceptable, and it should not continue. Thank you.
Would you like me to respond to that now?
Thank you, Madam Prosecutor. Yes, but I will first, Mr. Kihu, please, and then we'll continue the... Mr. Kihu, please. And in a concise fashion, because we have to move on to the next item in the
Yes,
agenda.
Your Honor. I get the
Thank
feeling
you.
that we're living in an alternate universe here. What the prosecutor said in their submission on the Rule 102.1b was that they are nearing completion, but they're working at maximum capacity and efficiency to the detriment of our clients. Because remember, this trial was supposed to start a long time ago. Nearing completion. When? They're asking for an extension for over 1,000 documents, 1,000 in Albanian, over 700 in English, that were not, they want an extension until the 31st of January of 2022. How is this not to the detriment of these 4 men who are sitting in jail? And when they say nearing completion, Your Honor, they have told you that before. What does that mean? I mean, nearing completion, for most of us, Your Honor, I don't want to speak for you, is nearing completion very soon. Not another 3 months, which is what we're looking at. Another 3 months before we even get 700 documents in English, which of course we need, and my client gets the 1,000 documents to be translated into Albanian. I am shocked that counsel for the prosecution stands before you to try to justify the regime that they've employed in this. If they didn't have enough translators, it was incumbent upon them to hire more, get more, finish their investigation. We can get to the investigation, which is still ongoing, as they note. But there has to be an end to this. There has to be an end as 4 men wallow in jail while the prosecution dithers. And with all due respect, when they say nearing completion, it's got to be complete. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
I'll take it briefly, but I'm certainly not going to accept rebukes about misleading the court or about my tone from somebody who stood up right the way through these proceedings and made entirely misrepresented factual statements about when the prosecution would be ready for trial, about when it would disclose its material. She's accused me of misstating the facts, but is not able to point to a single example. What I actually said, and I hope there's no dispute about this, and if there is, kindly, I'd invite her to review the transcript and correct what she just said. But what I said was that at the 21st of July status conference, this prosecution promised, untruthfully, that it was at that stage substantially on track to meet a 23rd of July deadline. That means at a time when 2 days before it must have known it was not substantially on track. That representation was made to you. So you may not like my tone, she may not like my tone, I don't much care, frankly, because the tone ultimately is determined by what is going on here. I understand that with such close attention to the procedural detail that Your Honour needs to pay to try to keep this case on the road, it may be difficult to keep a balanced overall perspective on how this proceeding is being perceived. It may be difficult when you're so closely involved with the detail to understand exactly how an objective observer would view the way this prosecution is behaving and the way they are not, frankly, being restricted, controlled or managed. So if there is frustration in the way I put my submissions, there absolutely should be. It's fully justified, and nothing is going to change it except some muscularity in terms of controlling the way the prosecution behaves. It's an interesting fact here that the only lawyer you've criticised for taking too long is me. I find that very surprising.
I haven't been criticized you because of that. I mentioned your tone towards me, Mr. Emerson.
I have not been rude to you at all, other than not to sit down every time you interrupt me. And I'm not going to, because that's not the sort of advocate I am.
Thank you, Mr. Emerson. Mr. Roberts, please.
Thank you, Your Honour. Just on this issue, one very brief point, and that's in reply to the last thing that the prosecution mentioned in relation to the deadline, the original deadline for Rule 102(1)(b) disclosure, and that the deadline of 31st of May 2021, which was originally ordered by Your Honour, was apparently delayed by the defence till the 31st of July because we had asked for categorisation, as if it was our fault. What we had asked for and what you had granted was for the prosecution to disclose their 102(1)(b) material in accordance with a proper interpretation of that provision. But that attempt to shift the blame and responsibility onto us for delays in proceedings appears to be somewhat symptomatic of the strategic approach taken by the prosecution. There are delays. It has taken a very long time to get where we are, which is still a very long way away from the beginning of trial. So therefore, it needs to be our fault. Your Honour, disclosure of 102.1b material is the prosecution's responsibility. It is not ours. We have tried to help them, and I will address the specific examples of how we've tried to help them later, because they don't seem to be able to identify that method of doing it by themselves, but it's their responsibility. And their attempts to shift that responsibility, that burden onto us, are inappropriate in these circumstances. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, briefly, please.
And on the last point made by Mr. Roberts, of course, that deadline of the 31st of May of this year was not one that Your Honour had plucked out of the air. It was the date that the prosecution suggested to you, Your Honour, in their submissions F76. That was the date when the prosecution said it would be ready to disclose the Rule 102.1b material. So it's quite clear on whom the delay falls. Right.
Thank you, Mr. Ellis. We will now move to the request of the defense for Mr. Selimi regarding the need for the SPO to first specify in legal workflow which document and translations, revised or lesser redacted version of previously disclosed materials, or simply have revised metadata. Second, review all documents categorized or linked to Mr. Selimi. And third, create witness entities in legal workflow for all the witnesses on the SPO's preliminary witness list. Mr. Roberts, you have the floor to present your requests. Thank you. And briefly, because you already made very detailed written submissions, so no need to go in detail about every point, please. Thank you.
Thank you, Your Honour. I have no intention of going into any detail, really, beyond what was set out in our submissions. I've identified exactly what we want. I've identified why we think we need it. And I've even identified, to help the prosecution, how they can do it. I have had the advantage of being involved in the creation of the legal workflow system a very long time ago in a former life. And so, therefore, any assistance I can provide to the prosecution in a constructive manner is what I'm seeking to do. And we're at the stage now where we really need to do these things. Legal workflow is supposed to be a complex system which assists disclosure. But, and there are a variety of different ways for using this expression, it's only as good as what you put in it. And if you don't put the work in at the beginning, and it's the prosecution who are in the position to do that, then it exponentially increases the amount of work that you need to do from a defense side, and reduces significantly the utility of it. So we're now at the stage where I think these three concrete, achievable and helpful objectives and requests should be something that the prosecution would welcome and hopefully would be able to implement effectively and efficiently. I have nothing to add, but can certainly respond or reply if necessary. Thank you.
Thank you, Mr. Roberts. And I note your offer to become a consultant for the SPO on legal workflow today.
For a fee, Your Honour.
Before I give the floor to the SPO, I would like the other defense team to indicate if they have anything to add, or if they want to join the request, or if they can provide any other example of problems that are mentioned in the request from the defense from Mr. Selimi. Mr. Kihu, please.
Yes, thank you, Your Honor. We certainly join the Selimi request in this regard. If I can just highlight one practical issue that we have had, of course, is going through witness statements, and when a document is identified by a number, that very, very often doesn't match any number that is part of any disclosure. So to compound the problem, we'll get a witness statement, and any document that happened to be shown to the witness may not be disclosed at the same time and may be part of another disclosure. So how do you find that document if the numbers don't match? And sometimes they do, but many times they don't. You have to go through word searches for these thousands of documents and try to make an educated guess as to whether or not this document matches up with what they showed the prosecution witness when they took the statement. I know this sounds quite elaborate, but the folks that are with me are nodding their head because they're the ones that are doing this. There has to be a better way, and I think what Mr. Roberts is laying out in legal workflow is the methodology we should employ to get that done.
Thank you, Mr. Kihu. Mr. Emerson, please.
I've had a chance to discuss with Mr. Roberts both the submissions that he's put in writing and the submissions he's made on this issue, and indeed the submissions that he's going to make in relation to the disclosure regime that has been imposed in relation to unused material. Subject to listening to what he has to say, I adopt everything, both that he has just said and that he is to say, but I may have one or two observations to add.
Thank you, Mr. Emerson. Mr. Ellis, please.
Yes, thank you, Your Honour. We also adopt that position, but witness packages, the linking of documents to witness statements is a topic about which you've heard from our defence team at a number of previous status conferences. It is, I'm afraid, déjà vu all over again. The difference this time is perhaps that we now have the preliminary witness list from the prosecution. As I understand it, there can now be no objection to creating, finally, these witness entities on workflow. It seems to me that from everything that we've heard so far in the case, this isn't going to happen quickly without a deadline being imposed, and we would certainly ask Your Honour to do that today. The prosecution should be ordered to ensure that those entities are created and given a deadline to actually link the documents to the witnesses.
Thank you, Mr. Ellis. Let me turn to the prosecution. I'd like to hear the SPO on the request from Mr. Selimi on the three aspects related to the Rule 102.1b material linkage, including especially this issue of the witness package, because as rightly pointed by Mr. Ellis, now that the preliminary witness list has been filed, this should enable the parties to use legal workflow to that end. Madam Prosecutor.
Thank you, Your Honour. I would like to start with one factual correction. I referred to the 31st of July previously, and the date in question for Rule 102.1b material was the 23rd of July. We had a separate deadline for the 31st. We certainly welcome the Salimi defence's offer of constructive engagement, and we're always happy to have staff or consultants who are familiar with legal workflow. However, on that note, many of the specific matters identified in the Salimi submissions had not been brought to our attention inter partes. It has been repeatedly emphasized that doing so would allow certain queries to be addressed in a more efficient manner. And in fact, Your Honour has previously encouraged the parties to try to address precisely these type of disclosure queries in an inter partes fashion. The first issue identified by the Salimi defence related to how redacted or revised items are associated with each other. Revised or lesser redacted versions of documents maintain the exact same core ERN number. Documents are searchable by ERN in legal workflow. So any time that the defence searches the core ERN, all revised and redacted versions will be retrieved together with associated metadata, such as the date upon which they were disclosed, and that allows easy identification of the most recent version. Moreover, on the same day that Disclosure Package 82 was released, and this is the package specifically mentioned in the defence's written submissions, the SPO sent the defence an email explaining that the disclosure package in question contained revised and lesser redacted versions. Similarly, with respect to translations, the SPO consistently identifies translations as such using the is translation field in legal workflow. And we also consistently use the relations function in legal workflow to associate translations with their originals. The Salimi defence has identified an instance in which that appears not to be done, and we will review and, as necessary, correct the relevant metadata for that item. The document in question is already both identified on its face as being a translation, and the ET addition to the ERN clearly indicates it as a translation. We note for the benefit of all parties that we are also already conducting our own review of such metadata to ensure that all linking of translations has been properly implemented. With regard to the subcategorization of materials, the Salimi defense identified 6 documents for which it does not understand the categorizations indicated, and it seeks to extrapolate from there that the categorizations provided are a mere lottery. Again, that type of hyperbolic language is misplaced. We certainly don't exclude the possibility that there may be a small number of errors in an exercise that involved manual categorization of in excess of 11,000 items, and we will review the categorizations identified by the Salimi defense. However, the accused were not only tagged where they are specifically named in a particular document. An item of evidence may relate to an accused or to their responsibility without specifically identifying them by name. And if the SPO were to have confined itself to only tagging an accused where they were specifically named, that type of subcategorization would have added no value to what could be achieved by doing a simple word search on the accused's name in legal workflow without any categorization at all. It's therefore not actually apparent from the Salimi defense filing that there was an error in the categorization of certain of the documents that they have identified, but we will nonetheless review them, as I indicated. Finally, in relation to the linking of items to witnesses, to date, subject only to applicable protective measures, the pseudonym of the relevant witness is included in the descriptions of relevant statements and testimony, and that information is searchable through export of a CSV or Excel sheet. Exhibits shown to or used with a witness during their SPO interviews are also in many instances disclosed together and again with the relevant witness pseudonym indicated in the description. In addition, in the emails which the SPO provides to the defense following release of disclosure packages, it is specified which witnesses the disclosure package relates to. However, for certain items, for example, where an exhibit has been used with multiple witnesses or where it happens to have been shown to a particular witness but doesn't specifically relate to them as such, we do not consider that including the pseudonym in the description is an appropriate solution. The ERNs that are referenced in the transcripts are searchable in legal workflow. But apart from all of that, as previously indicated, and as also reflected in the Krasniqi defense filing, achieving linking of materials to witnesses through the relations in legal workflow is something that has been part of inter partes discussions, and it is something that the SPO is now advancing. Following the filing of the preliminary witness list, indeed, we will be working with the relevant sections of the registry to create witness entities in legal workflow, and then to arrange for the prior statements and associated exhibits to be linked to those entities. This will only be subject to applicable protective measures, which may require that certain exhibits, which could be identifying, not be linked to a witness at this time. There were some technical difficulties encountered in creating the witness entities in other cases, but work has been done to try and resolve that, and the linking is something which we will work on as a matter of priority in the coming weeks. Finally, we confirm that we would be happy to participate in a working forum of the type proposed in the Krasniqi defense's written submissions. Thank you.
Thank you, Madam Prosecutor. Before I give the floor back to the defense, are you in a position to give a timeline for the different proposals that you made to respond to the defense request? Thank you. Or timelines, plural, maybe.
Yes, Your Honor. The witness entities have to each be created manually, individually, and the relevant relations to evidentiary items then have to be made. We also have to conduct careful checks to ensure that delayed disclosure witnesses material, which, as I mentioned, material which may be identifying to ensure that that is not linked. It is something which takes a degree of time, but we would anticipate being able to complete it by the middle of December. Thank you.
Thank you, Madam Prosecutor. I turn to the defense. Maybe Mr. Roberts, because you filed a request.
Thank you, Your Honour. Very, very briefly. So it basically seemed to be a no and ultimately a yes to my three requests from what I could gather. We'll see what happens with the review of the documents. We stand by, obviously, what was set out in our written submissions. The system does allow for a more easy-to-manage way of linking redacted versions, previous versions, translations. Some, obviously, is a matter of whether mistakes were made. Other times, it actually needs to be a systematic approach to the SBO to ensure that that's done properly. But we will constructively engage with the SBO. Now this issue is before you, and try and make sure that that does happen in the future. Just on the last point in relation to the disclosure and creation of witness entities, obviously protected witnesses is more of an issue. As I believe the prosecution mentioned earlier, there were 210 or 220, I can't remember, non-protected entities or witnesses on their list. So I would imagine there's quite a lot that they could be getting on with already without having to worry about the protected witnesses. And on that issue, we shouldn't have to wait until mid-December until we get anything. One would presume, and I'm sure the prosecution, if they're able to do this, would be willing to do so, should be able to disclose those entities on a rolling basis. And obviously the earlier and the more effective, the earlier that's done, and that we can make use of that material, the better for us. Thank you.
Thank you, Mr. Roberts. Briefly, Madam Prosecutor, on this specific point.
On this specific point, and only to express agreement with the Salimi defence, that is indeed how we plan to go about the work. We will do it as much as we can on a rolling basis, and we are going to prioritise the witnesses for which there is not a delayed disclosure issue. Thank you.
Thank you, Madam Prosecutor. Let us now move to the Rule 102.3 notice and evidentiary material. I remind the parties that on 14 October 2021, the SPO requested an extension of time limit for, first, the Rule 102.3 request submitted by Mr. Krasniqi on 7 October 2021, and second, the materiality review and disclosure of any future defense request for Rule 102.3 material. On 18 October 2021, I suspended the SPO deadlines in relation to the Krasniqi request and those related to the materiality review and disclosure of any future defense requests for Rule 102.3 material until I issue a decision on the request. I ordered the defense and victims' counsel to make observation on the SPO request, if they so choose, ahead of this hearing. I note from the SPO submissions that it reiterates its request for an extension of the deadline for materiality and protective measures reviews in relation to the Krasniqi request, as well as a general extension applicable to all Rule 102.3 deadlines. With respect to these three requests from the Vasile defense made between 16 and 22 October 2021, the SPO additionally requests an extension of the deadline for materiality and protective measures reviews until 1st December and 17 December 2021, respectively. I also note that the defense for Mr. Salimi requests that Rule 102.3 material be disclosed in its entirety, while the defense for Mr. Krasniqi requests that the 5 November 2021 deadline for defense indication in relation to Rule 102.3 material also be extended. I inform the parties that I intend to issue an oral order at the end of this hearing on this topic. And on that note, we will start with the prosecution. Madam Prosecutor.
As indicated in our written submissions, the SPO has so far received 15 Rule 102.3 requests. 10 of those have been processed to date. The 10th one, that of the Salimi defence, was disclosed a short time ago today, Disclosure Package 108, and a related protective measures application has also been filed, filing 552. Of the 5 requests which are now currently pending, 4 of them have been received within the last 2 weeks, and those 4 requests relate to 16,154 items. The SPO has also taken note that the Krasniqi defence indicates it is preparing further Rule 102.3 requests, which will be of a similar or larger size to that of their most recent request for 8,000 items. It is also noted that the Salimi defence anticipates making a request for almost 40,000 items, with additional requests to follow. Although the deadlines for processing are currently suspended, the SPO has continued to work on the requested disclosures. We remain on track to process the Krasniqi request for 5,945 items by the dates previously indicated. With respect to the Salimi defence's written submissions, there are unfortunately a number of sweeping and unsubstantiated statements in relation to the Rule 102.3 process generally. The SPO does not dispute that the process envisaged by the rules is a cumbersome, multi-stage one, which places a significant burden on all of the parties. However, to date, the Salimi defence has effectively not engaged in this process. Despite having had the Rule 102.3 notice for almost 3 months, that defence team has made only 1 request for 123 items. Now, with a week left before the 5th of November deadline for the making of requests, the Salimi defence indicate that they will be seeking almost 40,000 items. Absolutely no explanation is provided for why some of those items could not have been requested sooner to facilitate processing on a rolling basis, as was mentioned at the last status conference. It is inevitably the case that if a request for 2/3 or more of the items on the notice is filed or submitted inter partes in the final week in which requests are permitted, a considerable amount of additional time will be required to process it. With respect to the recipients of Rule 102.3 disclosures, unless other teams are copied on an email request or it's otherwise indicated to be a joint request, disclosures are released only to the requesting team. This is a matter which the SPO advised the defence of back in February 2021, and we more recently confirmed it again to the Salimi defence. So far, we have received only 1 joint Rule 102.3 request, and that was made back in February. The SPO would be happy to receive joint requests which have been coordinated amongst the defence teams, and we do invite the defence to do so. However, in the absence of that, we will continue to provide the requested materials to the requesting parties. To entirely upend the applicable disclosure regime at this stage and simply request, as the Salimi defence has done, that the SPO now disclose all of the listed materials to all of the defence teams, regardless of their materiality to defence preparations, is belated and fails to recognise the nature of the Rule 102.3 process. It's fundamentally different from the Rule 102.1b and 103 processes, where there is a positive obligation on the prosecution. With the Rule 102.3 materials, it is for the defence teams to select items that are material to their preparations. The fact that thousands of items have already been disclosed pursuant to this rule, and many more have been requested, shows that this is possible. Moreover, the SPO has spent approximately 9 months providing defence teams with detailed notice and processing the requests received to date. In the circumstances, our request at this stage is for the defence teams to make all of their remaining requests for items from the existing Rule 102.3 notice by the applicable deadline of the 5th of November. The SPO will then be in a position to assess those requests and the time necessary for processing them. We note that the Krasniqi defence team has sought an extension of that deadline, and we do not oppose that request should Your Honour consider it necessary. However, we ask that a deadline be imposed so that we have a firm date, we know the volume of materials that is sought, and we can assess the overall scope and make relevant submissions on timeline. We also request that in the interim, the processing deadlines do remain suspended, but with the understanding that we will continue to work through the requests received as efficiently as we can. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor. Once again, I'm stunned. The prosecution wants to hold us to a deadline for requesting 1023 material when they haven't made all the prior disclosures under 1021B, which is a remarkable position to articulate in a courtroom. They're in here asking you to delay a disclosure, at least of some of the 1021B documentation and the translations to the end of July. But make sure that you toe the line on the defense and make sure that they comply with the applicable timeline. It's ridiculous. I mean, we got witnesses. They took witness statements, Judge, less than 2 weeks ago that we received in this package. We're supposed to get more. We don't know what's in these 732 documents to be translated into English. How are we supposed to give any type of any type of notice under 1023? As opposed to setting out a deadline, we respectfully ask the court to hold the deadline in abeyance until we get this discovery, get these disclosures in order, and we can have a rational conversation about how long it's going to take to go through this material and what type of notices do you anticipate. I mean, we can go through it as quickly as possible. We still don't know how much material we're going to get. So how in heaven's name could we possibly give you a fulsome or complete 1023 disclosure, Judge? I'm just being as perfectly honest as an officer of the court as to what we're capable of doing. And for the prosecution to say, well, we should toe the line and abide by the deadlines, it's just inconceivable. If we're going to go through this rationally and they're going to continue to delay the disclosure process, then there has to be a concomitant holding in abeyance of our documents requested under 103B. It's just as a logical 1023. It's just a logical sequence of how it has to go. And certainly that's envisioned by the rules. So at this point, Judge, because of everything we have to do because we don't know it, we ask you that you hold that deadline in abeyance until Your Honor can have a more fulsome discussion and we can attempt to educate you as to what's involved once we see the stuff.
Thank you, Mr. Kihu. Mr. Emerson, please.
Yes, can I start from the basics here? Because obviously this category of evidence is let's call it a database from which the prosecution has selected evidence that it wishes to rely upon at trial or that it considers may be helpful to the defence. Well, as a general rule and in general experience, it's never wise for a court to rely on the prosecution to decide what might be of assistance to the defence, because they don't know what the defence is, they don't know what issues may be relevant to the defence, and above all, they're likely to take the narrowest possible view of material that may be of assistance. It's just the way the world works. Now, in most jurisdictions, the prosecution nowadays are required simply to disclose their unused material so that the defence has access to the entirety of it, can read it, and see what of that material may in fact be of more use to them than the prosecution first envisaged. That's, in the end, what's going to happen here. However, and I'll go through the mechanics and the details in just a moment, but I'm going to suggest to you at the end that Mr. Roberts is right, that the only way of us to solve this is we just make an application now, or by the 5th, or whenever you like, for the whole lot. And let's see how long the prosecution takes to do it, estimates that's going to take. Because why do I say that? Just to be clear, we first of all received the list itself. We have since receiving the list, we have made requests for 7,785 documents on the 21st of August, 2,202 on the 16th of October, 2,855 on the 19th of October, 26,892 on the 22nd of October. Those were based on a very simple criteria, which is, was there anything on the actual face of that inadequate index that was first exposed to enable us to identify that might relate to our client. So it's a very, very superficial process. Out of a total number of requests, which, as you heard, go into many, many thousands of documents, we've so far received 19. Now, on the 25th of October, so just the other day, the SPO finally provided an amended notice with more complete descriptions, but only for 24,842 to be precise, entries on the list. And as matters stand, if we were straitjacketed in within this frankly crazy procedure, we would have to go through those 25,000 summaries and make a decision on the hoof based on the summary as to whether or not there might be something in it that we require, and notify that by Monday, is it, or Tuesday? I mean, that's obviously unreasonable. But it leads us on really to a general question. Why is there a deadline at all? Why are there limits at all? First of all, why is there a deadline? It's obvious that what is relevant to our defence is going to change over time. It's going to change with the service of the pre-trial brief. It's going to change with the service of the 109. It's going to change with the late disclosure that may come in January. But above all, it's going to change during our investigation, which is now, and let me make it clear, I don't think any of counsel will disagree here, there's no prospect of us starting a trial in 2022. Absolutely none at all. Yeah, we are looking at the very earliest possible date, maybe to get opening speeches in before December. But realistically, the vast amount of material, there are 300-odd prosecution viva voce witnesses. Obviously, I mean, just looking at how long other cases have taken, it is obvious that the process of investigating that case is going to take at least a year for the defence. In the meantime, as we are investigating, because there's no, I mean, it would be, this is why what I was saying earlier is relevant and wasn't to be swept aside in perhaps the way summarily it may have seemed to be. If there was an actual case against certain of the accused, or let's take my client, if there was a definable case, we wouldn't need to be worrying about 185 or 285 of the witnesses. We'd just be focusing on a few of them. And that's the way it's been with every other international criminal prosecution. The crime-based evidence is usually agreed, or to a large extent, and there will usually be a number of key witnesses who point to the criminal responsibility of the accused. there is none of that. So far from making our job easier, it makes our job much, much harder. The consequence is, of course, what's in that big repository, its relevance may pop up at any given time. We come across a witness, he says, I was such and such, I was in a certain place and gave an interview to so-and-so, we might have to look at the database. So obviously the 5th of November is ludicrous. Even the 5th of December, the 5th of January, or the 5th of November next year is ludicrous. Because what is relevant and therefore essential for fairness and the fairness of the trial is that we have access to the same body of material as the prosecution. It's basic equality of arms. They've made their selection from that bulk of material. We now make our selection as well. So we need to be able to read all of that material if we want to. And it's not up to the prosecution to make decisions about which parts of it they're prepared to give to us and which they're not, or requiring us to make requests based on an entirely unintelligible index, or starting to give us 19 items out of requests for 20,000. No, it's very simple, and I think I'm supported in this by all defence counsel. The only way you can deal with this is to just say, okay, enough. They disclose that whole database, and if that means they've got to redact some stuff, get on and redact it. Do your job. You know, they should have done all of that before they arrested these men. All of that preparation was all foreseeable. And of course, during the trial, we need that database as well. Witness might come in, they might say, well, I was in I don't know, some part of Albania at a certain time, and I did it, and we want to search the database. We're absolutely entitled to the whole lot of it. There's no reason whatsoever why we shouldn't have it. Fairness demands that we should have it, and therefore I think I speak for all of the defence in saying we must have it. So let's stop messing around with them giving descriptions and us making requests and dates and so on. Just hand over the whole database so that a fair trial can be had. If they're saying we can't do that because we haven't read it, then that in itself shows a dereliction of duty. If they have read it, and they do know what's in it, then they ought very quickly to be able to disclose it. And they ought to have anticipated the need for any protective measures or redactions necessary in order to do that. But the simple fact is that was work that should have been done before they arrested these men. All of this should have been done before they arrested these men. It's no good saying now, oh, it's going to take forever for us to do that and we haven't got the resources. And I'm sorry, I'm going to apologise to you if you don't like the tone of the way that I address the court. We're being criticised, all of us, by the prosecution for using hyperbole. Hyperbole means exaggeration, overstating the case. What we're saying is only hyperbole if the truth does not match up with it. And I'm sure whatever you say or don't say in public, you are shocked and dismayed, you must be, by the way the prosecution is behaving. We are rather disappointed that you haven't said anything on public in order to bring the prosecution to book. In other words, to reprimand them and to expose this chaos. All right? But be that as it may, I take exception to the tone of counsel opposite. I take exception to the complete complacency to the fact that these men are in custody, which characterises every single word that falls from her mouth. The failure to acknowledge and apologise or express the slightest remorse for misleading the court and the accused into detaining these men on a false basis. I personally find the emotionless tone of an automaton rather an inappropriate way to deal with a situation where she stands there as the representative of an organisation which is failing to an extraordinary degree, not fit for purpose. And to stand there and simply read things out as though this was a normal situation, and then criticise us for hyperbole, I'm afraid she's a good spokesman in the sense that there's not a crack in the armour. There's no sign of compassion for these men. There's no sign of any real need for justice or urgency, just excuses. And the moment it's taken beyond that, she complains about the tone of others. She's here to make excuses for the inexcusable, to defend the indefensible. So I do take exception to her tone in that respect. As far as these documents are concerned, the solution, and the only workable one, is for us now formally, and I'll do it here in court, I request all of those documents, and I'm within my deadline.
Thank you, Mr. Emerson. I see that it is 4:17. I guess the interpreters would need a break. I am told that we need to have a break. It is 4:17. We will reconvene at 4:45, so in 28 minutes. The hearing is adjourned.
All rise. All rise. Please be seated.
So I think we heard from two defense teams for the Rule 1023 material, and I will now give the floor to Mr. Roberts, please.
Thank you, Your Honour. Fortunately, I fully support and second, obviously, what my colleagues, Mr. Kehoe and Mr. Emerson, have already said. Our position is set out quite clearly in our written submissions. We do think the only logical, fair, sensible approach is now to disclose to us every single one of the 68,000 documents on the list. I have three very brief points to make in relation to this. Firstly, I think it's important to recall, and this is my understanding, and I'm sure the prosecution will correct me if I'm wrong, but this isn't their entire evidentiary holdings we're asking for. They have already made a selection down from their initial estimate of 100,000 down to about 68,000. So they've already made a determination, a prima facie determination, but a determination that those 68,000 documents are potentially relevant for the case. Obviously having seen the content of the documents as well. So on that basis alone, I think we have a completely justified request in order to see all of those documents. Now, secondly, the type of case that we have here is not the same as the other cases at this tribunal. The two other cases at this tribunal, which you're obviously far more familiar with than I am, being the pretrial judge in both, concern a contempt case and a single accused, single crime site location case. So the Rule 1023 process that was followed in those cases obviously is far, far, far more limited and more restricted than the cases, than the documents and the process in this case. Now, my understanding, and again, this is only from public information, is that in the Mustafa case, it was around 417 items on the Rule 1023 list, and in Gucciati and Haradinaj, 200 or so. Again, I don't know the precise figures, this is from public filings. Total of about 600 items across the two cases. We're 68,000 documents across the two cases, less than 1% of the total volume of ours. And the reason we have such a large number of documents is the way the prosecution has pled its case. It is a very, very wide-ranging alleged JCE with a wide variety of different alleged perpetrators, be them members or tools. To be honest, we don't even know, and the prosecution has not been required to plead. So in consequence, or as a consequence of the case that they have pled, that is why we say that all these documents potentially could be relevant to our case. And we should not be forced to make a choice and self-select documents that we are not allowed to see based on information that we don't have. The only sensible way to move this forward, and I genuinely am trying to be as constructive as possible in this scenario, is to give us all the documents, and then we can search for them and work out what we want. And obviously my colleagues have explained how that will be done at different stages of the process. And obviously, that doesn't mean that they have to give us everyone straight away. They can, for a start, give us every single one of the documents for which they do not require protective measures. They do not require redactions. For example, the first 39,000, to give a figure from our filing. And then they can focus on the protective measures and redactions, and they can focus on whether there needs to be those protective measures and redactions. Because at the moment, we're in a situation where if one team requests a document, then it's entirely likely that the prosecution will need to seek redactions or protective measures for that document vis-à-vis the requesting team. The other teams are not allowed to know, obviously on the basis that we have agreed so far, whether that document is redacted or whether that document has been requested or not. So, for example, the Thaci team requests a document, we go through that entire process. A month later, maybe we want that same document, but because we were not part of the initial proceedings, we therefore have to go through the whole process again. It seems to be a very flawed and complicated way of achieving the result that we want, which is to get hold of the information we need as effectively and efficiently as possible. And just to finish, I was amused, I'm often amused, but I was particularly amused that the prosecution stated that we were somehow not following the proper procedure by waiting until the last minute to request the 39,000 documents, and that if we'd just asked for some earlier, it all would have been fine. Because we did ask for 123 documents on the 24th of September. And we got them about 2 hours ago. And to follow up what Mr. Ellis had already said, it may well be that you need to schedule a status conference every day, because that seems to be the only way that we get clear and concrete responses to our disclosure requests. The reality was that we did have a large number of documents we had identified as being relevant, but if the prosecution is unable to even deal with the requests that had been submitted, what would have been the point of us submitting a further request at the same time? The reality is the only way to deal with this, and obviously second what Mr. Emerson has said, is to give us all these documents and to do so as expeditiously as possible. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, please.
Your Honour, we have been trying to make our requests on a rolling basis, but we have also now reached the point where we agree that the most practical solution is simply for the prosecution to give us everything on the Rule 1023 list. In addition to the points that have already been made by others, two things only. One, it seems to us that the process may have been just about working when defence teams were asking for a couple of hundred documents. But it was as soon as we made a request for almost 6,000 documents that the prosecution had to ask Your Honour for a more general series of extensions. But that request for 6,000 documents, of course, is a drop in the ocean when you look at an overall list of 68,000 documents. It's less than 10%. And the reality is that there are, if we move forwards as we are set to move at the moment, there are going to be an increasing number of these requests for thousands of documents. We've seen in writing that the Salimi defence have a request prepared for 39,000 documents. There will be similar large requests, I'm sure, from all defence teams. And if a request for 6,000 documents is needing extensions, how long will it take to respond to the 39,000? How long is it going to take when all the defence teams start asking for up to 50, 60,000 documents? In our submission, the system is going to increasingly fall apart as we move forwards. The second point, Your Honour, is that at the last status conference, we identified the link between the need to review the prosecution's disclosure and our ability to make requests from the list. And I think Your Honour accepted that proposition in our extending our deadline in an oral order at the end of the last status conference. Of course, that remains the position, and that would mean that if the prosecution is not finishing its 1021B disclosure until the end of January, then the deadline for any defence requests for 10213 material would then have to go back into February sometime. And with rolling requests being made all the time up to that point, we are all going to be stuck here litigating Rule 1023 requests for the next period of months, Your Honour. And in our submission, this is just going to suck increasing time and resources out of all of the parties and slow proceedings down. The time has come to just cut through this and say the defence teams want everything on the list. And otherwise, we are all going to get bogged down and slowed down in this matter.
Thank you, Mr. Ellis. Madam Prosecutor.
Thank you, Your Honour. The Vercelli defence team raised the issue of foreseeability, and certain of the teams have now requested that all items on the notice be disclosed. It's certainly the case that the SPO has been aware that a large volume of materials would be listed on the Rule 1023 notice. But that does not assist in the time required for processing the requests, and it does not equate to foreseeability. First, it doesn't take account of the fact that under the applicable framework, the SPO is obliged to provide notice very broadly and with very little discretion. whereas the defence are then to select pertinent items from the notice which are material to their preparation. The framework under the Rule 1023 regime requires disclosure of items which are deemed by the defence to be material to their preparation. A request for everything on the list is an acknowledgement, an express acknowledgement by some of the teams that this is not being done. They are simply requesting everything without any assessment as to materiality, and it is a misuse of the process. As Your Honour previously indicated in the framework decision, requests should focus on what is truly material to the case. And second, processing depends on the concrete requests which are made by the defence. It depends on the concrete redaction regime that's in place. It depends on knowing the concrete protective measures which have been granted. It depends on up-to-date security assessments for hundreds, if not thousands, of individuals. It depends on a page-by-page review of requested items, and it requires the drafting of specific materiality and protective measures requests. These are things which could not have been done in the abstract or in the absence of concrete requests. As I previously indicated, we don't oppose an extension to the defence for making Rule 1023 requests should they require it and should it be deemed necessary, but we do request there be a deadline so that the volume of what needs to be further reviewed, processed and disclosed at this time is known. We accept that what the defence consider material to their preparation may well change. However, what they consider material at this time should be requested and should be done in accordance with the framework and in accordance with an applicable deadline. Thank you.
Thank you, Madam Prosecutor. Yes, Mr. Kihu, no? Okay. No, you don't need to talk if you don't want to. Mr. Misson, please.
No, I just wanted to reiterate, this is not just a request made on the grounds that the current regime is unworkable. We've asked for tens of thousands of documents. We've had a handful. It's a principled request, and I'm asking you to rule upon it, which is supported not by some but by all defence teams, which is what is known as the common pool principle. And it's an essential foundation of the equality of arms required by Article 6, that both sides should have the same pool of material to look into and to see whether or not, if it has to satisfy the criterion of relevance, but all of this material by definition does, because the prosecution has categorised it as relevant. And we ought to be able to look at all of it in whatever form we want, not because we can't be bothered to make requests. We've made requests. We've tried to make the system work. But we will, as Counsel Mr. Ellis has pointed out, be engaged in satellite litigation until the end of next year on these issues, if it's dealt with in that way. But it's not just a question of practicability. There's nothing in the rules that says that a common pool principle should not apply. At the moment, in the way in which the prosecution has framed its case, and I can take that only from the generality of the indictment, the material put before you at the outset, but more recently, the list of witnesses that they propose to call, everything is relevant.
Madam Court Officer, can we go into private session, please?
And Your Honour, if I may, we would request a redaction, please, of the relevant portion of the transcript.
Your Honor, we are now back in public session.
Thank you very much. Let us now move to the Rule 103 material. I would like to know whether there remains any exculpatory evidence in the SPO's custody, control, or actual knowledge that must be disclosed to the defense, pursuant to Rule 103. In this regard, I note the SPO's submission that since the last status conference, 3 packages of potentially exculpatory items have been disclosed, and no protective measure request for such material is imminent. Madam Prosecutor.
Yes, thank you, Your Honour. You've accurately summarised the position. We are continuing to disclose potentially exculpatory items on a rolling basis as they are identified. That review does remain ongoing, and outstanding items are being worked through systematically. In addition to the 3 packages you mentioned, which have already been disclosed, 2 further packages are being processed and are expected to be disclosed within the coming week. No protective measures request is currently imminent. Thank you.
Thank you. Mr. Kihu, please.
Yes, Your Honor. I want to be very clear with the prosecution. Is it the prosecution's position that they have disclosed all witness statements that have exculpatory material? That's the question. And exculpatory material in this case is witnesses such as internationals have talked about the KLA being in disarray, about the KLA being disorganized, that the command and control was at a zone commander level. Witness statements along those lines, along those specific lines, I asked the court to ask the prosecutor if the prosecutor has disclosed all of those witness statements that the prosecutor has taken. On that very specific point, I asked the court to turn to the prosecutor and ask that question.
I will give the floor to the prosecution to respond to your question after I hear all the defense teams. Mr. Emerson, on the Rule 1023 material, please.
I'm just going to say this. I am aware of a number of people who have given exculpatory statements to the prosecution, and I'm aware of a variety of different means, which are clearly and unequivocally exculpatory, and they have never surfaced in the disclosure exercise. I put that on record now.
Thank you, Mr. Emerson. Mr. Roberts, please.
Nothing from me, just to second what's already been submitted. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, please.
Your Honour, Rule 102(1)(b) disclosure, ongoing, prosecution asking you for extensions. Rule 102(3) disclosure, ongoing, extensions requested. Rule 103 disclosure, also ongoing. There's a pattern emerging here. We're going to see it again with Rule 107.
Thank you, Mr. Ellis. Madam Prosecutor, and if you can provide your submissions following Mr. Kihu's question, please. You have the floor.
As I indicated in my prior submissions, the exculpatory review is not complete, and therefore it is not a confirmation that I can give. Thank you.
Thank you. Mr. Kihu, please.
The answer to that question is limiting. Again, these 4 men are in jail, and they have a 103 analysis still ongoing. And we have information that exculpatory information has been provided some time ago, and we have not seen those documents. And there has to be a reason why. And when I say that this information was given some time ago, several years ago, and we have not received that information. And that was why I asked the question, with all due respect, Judge, as to why that particular information hasn't been disclosed. If information of an exculpatory matter is not provided, that's got to be provided immediately to us. How do we know this doesn't bear on their continued detention? When the prosecutor just decides to keep it and not turn this information over, that's not sustainable. And we will act accordingly if this information is not promptly provided. So I say this to the prosecutor: search your records well for statements made by, for instance, international witnesses that have this type of exculpatory material, and it needs to be turned over as soon as possible. Thank you.
Thank you, Madam Prosecutor. No. Let us move to Rule 107 material. I would like to know whether the parties are facing or foresee any difficulties related to the disclosure process with respect to Rule 107 material, and whether any applications pursuant to this rule are imminent. Madam Prosecutor.
Yes, we have worked to finalize discussions with information providers. There are a number of items for which further progress and relevant decisions are anticipated, so we continue to pursue those matters vigorously. We've gone back to relevant providers on multiple occasions, conducting what are sometimes page by page or line by line discussions in order to minimize the scope of what cannot be provided. In the majority of cases, though, the process has now reached a stage where relevant decisions have been made. Therefore, to the extent that clearance of items has been denied, the SPO is preparing an application to the court, which we anticipate submitting shortly. We will also be submitting a shorter application addressing certain redactions applied by information providers to material associated with the 3 international witnesses whose material was recently disclosed. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
I'm in the complete dark about the Rule 107 information as to what's being disclosed, what's not being disclosed, how timely they moved to get this information cleared by the respective agencies. I mean, did they wait a week, a month? Did they do this 2 years ago? I can tell you the information of internationals that we're referring to gave statements years ago. And is the reason why that hasn't been disclosed because it's hung up in some Rule 107 process, and that's why exculpatory material hasn't been turned over? And when did the SPO go about to get that? Those are all questions that we can't answer because we don't have the information. I just put that on the table for Your Honor's discussion and thought.
Thank you, Mr. Kihu. Mr. Emerson, please.
You'll be pleased to hear I have nothing to say.
Ben.
I'm not pleased. I'm disappointed. Mr. Roberts, please.
I just have a question, Your Honour, and that goes back to our previous lengthy discussion on Rule 1023, but again is a constructive attempt to move this forward. How many of the 68,000 documents on that list would be subject to Rule 107, approximately? If the prosecution could give some indication of that, that may help us to actually understand how deep and big of a problem this actually could be. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, please.
Your Honour, the submissions that we've heard are submissions that are very similar to those that have been made on Rule 107 at every status conference. It's happening again and again. The process is still ongoing. We need an end.
Thank you, Mr. Ellis. Madam Prosecutor.
All of the items which have been listed on the Rule 1023 notice have been cleared by the provider. Otherwise, we could not have listed them. Thank you.
Thank you, Madam Prosecutor. I'm not sure this will satisfy the defense.
It does. It means there's no restrictions on them providing it to us, so I'm very happy.
Thank you. Let us now move to the issue of translation of filings and evidentiary material. I would like to hear, Madam Prosecutor, briefly then.
Very briefly, but I need to make a factual correction because there have been a number of items which were requested by the defence teams for which we are going back to providers and will disclose them once that clearance is obtained. I don't have the specific figure.
Thank you. Let us now move back to the issue of translation. I would first like to hear from the registry and the progress made with regard to the translation of several items, notably whether the translation of the decisions on preliminary motions are now completed, and whether the parties have made any further urgent requests for translation. In particular, I note the defense for Mr. Krasnici's concerns about the translation of core filings into Albanian, and I think this has been touched upon earlier today. And it requests that translation of the SPO's preliminary witness list and the SPO's pretrial brief, when available, be prioritized. And I would also like to hear from the parties of any further difficulties regarding translations, and if there are any filing that need to be prioritized. Mr. Roche, please.
Thank you, Your Honour. As regards the preliminary motions, they have all now been translated. That's filings F00412, 413 and 450. As regards the most recent request for a priority translation, which was the preliminary witness list submitted by the prosecution or by the SPO, that is an extremely lengthy document, over 450 pages. So we are working intensively to be able to give an assessment of when that will be ready, and we will revert to the parties as soon as that is available. We will also, as we have in previous cases, distribute an unrevised translation prior to it being revised in order to get it to the parties as rapidly as possible. There's also another request for translation of filing F00548, which came from Chambers, a reply from an authority in Kosovo, and that is to be ready by the 10th of November. More generally, as regards core filings, progress is being made on translating all of them into Albanian, and they're being distributed as and when ready, including an unrevised form where that is appropriate. Thank you, Your Honour.
Thank you, Mr. Roche. Let me now turn to the defense. Mr. Kihu, please.
Again, Judge, we're talking about a timetable here, and the prosecution, lest we forget, earlier today mentioned their request for an extension until the end of January on the translations of 760 items in English and 1,000 items into Albanian. That's in this translation mix, too. We look to Your Honor's guidance how we get this done as expeditiously as possible while these men sit in jail. But that's a lot of material to get through that these men need, and we need, in order to properly defend these people. It's not a pretty picture, pardon the rather pedestrian description. But that's where we are, and the only reason it's been a significant difficulty is while we wait for this, these four gentlemen remain incarcerated.
Thank you, Mr. Kihu. Mr. Emerson, please.
I'm concerned at the moment with one document only, and it was mentioned just a moment ago at the very end of the submission. That is to say, the time for translation of a document that emerges from another authority. I think I know what the reference is. Does Your Honour have any objection to me addressing the issue in open court?
As long as you don't give any detail about the content of the document, and if you just stick to the question of the timelines or deadlines, I think that's fine.
So, yes, so I think we probably I just want to make sure that everybody, that you, Your Honour, and Chambers know we are talking about the same document. It will be a document that was received on Wednesday the 27th, correct? I'm afraid the 10th of November is an impossibly long period of time for you to be able to read that document. We've had it fully translated in 24 hours. It's a critical document to issues pertaining to the liberty of my client, and it ought to be not just prioritised, it ought to be translated by Monday. You need to see this document. It's absolutely crucial. I've read it in English. You obviously haven't, and you absolutely need to see the answers to the content of that material. It's a matter of the utmost urgency.
Before I give the floor to the other defense teams, Mr. Roche, is there any way to prioritize or over-prioritize this document, or is the deadline of 10 November the best possible timeline?
Thank you, Your Honour. Obviously, there is a range of competing demands on the Language Services Unit within the registry, but I will contact them immediately and see exactly how quickly this can be translated. I cannot give a firm date at this time, but I will endeavour to do so as soon as possible.
Can I just
Thank you, Mr. Roche. Mr. Emerson, please.
Without speaking across, we have a deadline of Monday to respond in respect of the review of our detention. You will need to know what is in that document in order to conduct that review. I'm going to suggest that if the document isn't fully available through translation services by Monday, when the deadline is due, we will make our submission appending a defence translation of the document, which of course can then be checked by the translations unit. But our submissions cannot be made without the answers to those questions being incorporated.
I fully understand. Do you want me to postpone the deadline?
No. No, I want absolutely. I know what's in the document. I want the matter dealt with immediately. It cannot wait any longer.
This is noted.
So that being the case, there's at an appropriate moment. It was going to be the end of the agenda. I have a couple of things that I need to say to you about that process that need to go on the public record, but I'm unsure what it is precisely. Obviously the content of the document and the content of the request in the document are confidential, although there seems to have been some publicity about some of it at some stage in the media. But the contents of the request and the contents of the response are confidential, but they are not the only two documents in the sequence, because there has also been a request from the defence and a response from the same person, which has been translated, which I think you're probably aware of. So I want to make some submissions in relation to that. Could you clarify for me whether or not there's material, it's providing the substance, is the identity of the person to whom this request is made something you would regard as confidential?
I would regard this as confidential, but before that, isn't your deadline today for your submissions, the submissions you're referring to?
I thought it was Monday. Mr. Strong is on the other.
Yes, I believe it's Monday, because the filing came through after 4 p.m. last Friday, and so we didn't receive it until Monday morning. The prosecution response.
You received it on Monday? Yes. Okay.
Well, if I need to apply for extension until Monday, then I will. But this document is absolutely critical to that process. But could I repeat the question? In addressing the sequence of events, and it's important that I do, and I can do it later or now, is it your Honour's position that the identity of the person to whom the requests have been made is something that ought not to be put in the public domain, despite this judgment of the appeals chamber on the point, which obviously is public?
I mean, this is of course public, but I would certainly consider that the names shouldn't be in the public domain.
No, not the name, but the status, the rank, the person. A description of the person to whom the request is made. I mean, it's obvious from the reading the judgment of the appeals chamber.
I would need to think about it for a couple of minutes. Clearly the name shouldn't be in the public domain.
No.
The function, to be honest, if it's very generic and if it's very similar to I mean, I don't have the exact everything in mind at the moment, so.
Would you prefer I made the submissions in private session and then you considered?
I think that's probably better. We're going to move to private session to continue the discussion.
Disgraceful.
Your Honor, we are back in public session.
Thank you. Mr. Roberts, please.
Thank you, Your Honour. Nothing in relation to translations of filings. In relation to the request for translation, I can deal with that now, but I don't know if you wish to wait. The only issue is actually just trying to plan ahead. And again, I feel like I've repeated this multiple times, but we know, and this is the second elephant in the room that's coming up later, is the date of the pretrial brief. And the other issue that arises in relation to that is the translation of the pretrial brief. And my concern is that if we wait until the prosecution files their pretrial brief, until they start translating it, that translation will take a very long time to be provided to my client and obviously the other three accused. And also, it's not just the pretrial brief. There's obviously a significant amount of other information that's disclosed in relation to Rule 95. So I'm merely foreshadowing now that maybe it would be sensible, and again, the date of the pretrial brief is important, but it may be sensible to start planning ahead for that already, and already seeking to translate whatever sections of that pretrial brief could potentially be done, given its primordial importance to everybody in these proceedings. Now, obviously, certain sections will be hopefully have already been completed, because if they haven't, then obviously the prosecution's in a worse state than we think they are. And any sections that have been completed, it would make sense to prioritize the translation of those as soon as possible. So that's merely a suggestion. I hope it moves things forward, but it's something that, if it was possible to do, I think would assist. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, please.
Your Honour, I think Mr. Roberts has beaten me to it. That was why we identified the pre-trial brief translation in our written submissions. We don't want this to be the same process as I think occurred with the 863 outline, where it took a long time for the Albanian version to be produced. It's clearly a document that Mr. Krasniqi needs to see sooner rather than later, Your Honour.
Thank you, Mr. Ellis. And I think this is noted by the registry. Mr. Laws, do you want to add anything on the issue of translation, please?
Not on the issue of translation, thank you, Your Honour.
Thank you very much. I now turn back to the SPO to ask about the status of its ongoing investigations. In particular, whether the SPO can provide a further update on the estimated date of completion for outstanding investigative steps, whether there are any issues in relation to the SPO's preliminary witness list that has been filed on 22 October 2021, whether there are any anticipated issues with the deadline of 17 December 2021 being set today for the filing of the SPO's pretrial brief and related material pursuant to Rule 95, and whether there are any anticipated issues with extending the SPO's deadline for providing a Rule 109C chart to 28 January 2022. I also invite the SPO to make any submission on the procedural calendar in this case. I inform the parties that I intend to issue an oral order today and to set the deadline for the SPO to file its pretrial brief and related material, as well as a deadline for its Rule 1029C chart. In this regard, I note the submissions of the defense for Mr. Selimi that the SPO's pretrial brief should be provided as soon as possible, but no later than 26 November 2021. I will first give the floor to the SPO to provide its submissions on the remaining timeline for the pretrial phase. Madam Prosecutor.
My colleague will make our submissions on this agenda item. Thank you, Your Honour.
Thank you.
Thank you. Mr. Quick, please.
Excuse me. Thank you, Your Honor. With respect to ongoing investigative steps, I don't have much to add to prior status conference submissions. The SPO is responsible for continuing investigations within its mandates. We are aware of the applicable framework should further investigations result in material which we seek to rely upon. Judicial authorization may be required. Any such application would be considered at the relevant time with regard to the nature of the material in question, the timing and other considerations going to relevance and potential prejudice. Your Honor, in relation to the second issue you raised, which is the witness list, the SPO does not have any particular issues to address or to raise at this point. Moving on to the pretrial brief. In light of Your Honor's indication at the last status conference that you intended to set a deadline by this hearing in relation to filing of a pretrial brief, the SPO made submissions on that matter by way of filing F00520. Having carefully considered available resources and competing work streams in this case, the SPO confirmed that it would be able to file its pretrial brief and related materials on 17 December 2021. That remains the case. Indeed, the SPO has been actively advancing Rule 95-4 materials in parallel to all other obligations. Most recently, on 22 October 2021, the SPO filed its preliminary witness list. Such a preliminary list is not provided for in the legal framework and was provided at the defense's request and following Your Honor's order to facilitate defense preparations at this stage. The Salimi defense submissions challenging the proposed timeline for the pretrial brief are again unfortunately misleading in a number of respects. First, it is incorrect that litigation on preliminary motions has largely been completed. Up until 6 October, the SPO was completing responses to 81 issues and grounds of appeal on preliminary motions. There are now 27 grounds for which leave to appeal has been granted. Needless to say, the SPO will have to respond to all 27. The parties will be required to make submissions on these matters over the coming weeks, and such submissions will continue until at least December, considering the most recent extension of time granted at the defense's request by the Court of Appeals, and that's filing IA 12F4. As has been repeatedly recognized by both Your Honor and the Court of Appeals, the issues raised in the preliminary motions litigation are complex and require considerable time and resources to address. Taking into account the impact of preliminary motions litigation on the pretrial deadline is not only appropriate and reasonable, but also necessary. At other courts, the relevant rules did not even provide for the filing of pretrial briefs and related materials until after resolution of preliminary motion litigation. For example, IC2I Rule 65 Ter and Mixed Rule 70. Here, the SPO has undertaken to file the pretrial brief well before final resolution of preliminary motions. The Salimi defense also attempts to make an illogical distinction between available resources for legal and factual submissions, and this is at paragraph 43 of F00550. It is the same finite pool of SPO staff that must draft and review both, in addition to fulfilling other obligations in this case, including relating to disclosure. On disclosure, contrary to what the Salimi defense appears to suggest, it is simply not the case that where specific deadlines have been suspended, the SPO can just ignore pending requests from other defense teams. The Rule 1023 deadlines were suspended not for the SPO to set the requests aside and allocate its resources elsewhere, but so that a more holistic assessment could be made as to when the relevant disclosure could be effectuated as expeditiously as possible. For the reasons explained in our written submissions, that's filing F00520, 17 December is the earliest date upon which we can file the pretrial brief. The submission of a finalized pretrial brief is not just a matter of completing the drafting. There are multi-level redaction reviews and other checks which affect all sections of the brief and which are essential for the brief to be made available to the defense. Further, at the time of filing the brief, the delayed disclosure period for 21 witnesses ends, and the SPO must at the same time, through multi-level reviews and procedures, prepare those witness materials for disclosure. Finally, Your Honor, in relation to the Rule 109C chart, the same considerations apply as for the Rule 95-4 materials. Preparation of the chart cannot commence until after the pretrial brief has been completed and involves many similar checks as previously set out in filing F00520, paragraph 5. These submissions are based on the SPO's experience in other cases of smaller size and scope. 28 January 2022 is the earliest the SPO anticipates that it will be able to complete the chart if its requested deadline of 17 December is ordered. Otherwise, for any other deadline, 30 days following submission of the pretrial brief is the earliest the SPO would be able to complete the chart. To conclude, Your Honor, the prosecution, being given the time it needs to prepare the pretrial brief and related materials, is in the interest of the defense, in the interest of the victims and the chambers. The SPO proposal will expedite and facilitate, not delay the proceedings. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Mr. Kihu, please.
Your Honor, I would suspect that the court is fatigued, is probably the word, to hear about the SPO's finite staff and their competing work streams that are working at the maximum capacity and efficiency, while those 4 men on the screen sit in jail. The prosecution made the decision to indict this case and when to indict this case. No one else on this side of the room had anything to say about it. And now they're telling the court that because of their competing work streams and working at maximum efficiency, they can't get things done on a timely level. And oh, by the way, gentlemen, you stay in jail. That's what we just heard from counsel. Meanwhile, they also argue that their investigations will continue to the foreseeable future. What does this mean? This means that while they attempt to work on their maximum efficiency and with their competing work streams, they're continuing to investigate something else. What? What? Is it in investigating the charges that are in the indictment already? That investigation should be over. If it's some other investigation that my client is being investigated for, I move under Ori Tennis' move to terminate that investigation under Rule 47. Rule 47 is a vehicle by the accused, because he is an accused on something that he hasn't been charged with, that if in fact he is being investigated on something he hasn't been charged with, he is a suspect under the rule, not an accused as an indicted person, and a suspect under Rule 47 can move to have the investigation terminated, and we so move right now. To have any investigation outside of these charges terminated now. If they are investigating the way the rules contemplate investigating, to investigate something that they have charged already, that's improper too. That investigation has already been charged and those facts have been presented to Your Honor. So what, at the end of the day, with all these competing work streams and working in maximum capacity, and you have this vision of everybody sweating over at the SPO to get all this done, what are we continuing to investigate? And certainly this is not their delays as a consequence of that can't be viewed as anything but prejudicial to the accused in this case. Clearly, because just time just goes on. We have a pretrial brief in December, and the chart, our 109C chart, they want to put off until January. And I suppose the logical question for that, and I suspect most people in the room have done it this way, when you're putting a pretrial brief together, as you go along, you kind of note what your evidence is. I mean, maybe I just started doing this, and, I've done a few pretrial briefs in my day, and everybody, well, I shouldn't say everybody, usually When you're putting your pretrial brief together, Judge, and you say, what's our evidence for each one of these allegations? That's what you put in a footnote, and you turn it over at the same time. You know, I hate to sound glib here, Judge, but we're not putting a man on the moon. I mean, this is stuff that everybody has done before, but nevertheless, we're waiting for another 6 weeks after we get this pretrial brief to find out what's the evidence to support that stuff so we can start investigating that. It's just another delay, and frankly, it's a methodology that the SPO, for me, for the first time, has turned on its head. I've never heard of a pretrial brief being done in that fashion, but I suppose there's a first time for everything, and it's happened here. There are a lot of firsts in this case. That is difficult. Did you want me to go through the rest of the issues that you outlined, Judge, before I sit down? The brief that they are contemplating filing is 2 days after our next scheduled pretrial conference. Our pretrial conference is on the 15th. So we're not going to have any, according to their schedule, we're not going to have any fulsome discussion about the pretrial brief until sometime in 2022, based on their proposed schedule. That's just a note. I mean, two down the line. That's why my colleagues had asked, the Vasily team had asked for, October 31st or something at least in early November, so we can at least begin to discuss this and to get our arms around it at our next pretrial conference. But with their schedule, that's not going to happen. We're going to get kicked back yet further. And I hate to repeat myself, and the Rule 109 chart. I mean, the Rule 109 chart, it should be done at the same time, and I just, for the life of me, can't think of a reason why it wouldn't be. It just can't for the life of me. It's usually done so, as I noted before. The particular witness list that was given to us, and I think we've talked about this for a little bit before, they have 327 incriminating witnesses listed. They have, in that list, they have 266 witnesses testifying viva voce. 266. By the way, we got 20 dead guys in there, too. And one of the dead guys, he's also going to be presented live. So they have a listing there where he's dead, but he's coming live, and I know Ben wants to be here when that witness comes to this dead guy comes to testify. But it's true. So they have 20 dead witnesses, and then 57, any number of them, 61 in writing, which we're going to move to exclude. The time frame on this, I mean, we don't have, as I noted previously, we don't even have 102.1b material on 8 witnesses? I think it was 8 witnesses. We don't know anything about these people. That's on top of the redactions that are in the materials that we have. So are there problems with the SPO's witness list? There are a lot of problems with the SPO's witness list. Redactions, disclosure, we talked about in the beginning, that we have 122 pieces of witnesses that are, I trust most of them viva voce witnesses, for which there's no identification. That's 37% of the witnesses. 37% of the prosecution's proposed witnesses are being presented at this point with no identifying information. And what they give us in their witness statement are redactions are redacted, the names redacted, the times redacted, the events are redacted, who was there is redacted. And you look at this stuff page after page and you say, what am I supposed to do with this? I mean, reviewing this information is a spiritual experience because it's not providing us with any information as to what actually transpired. And why is that important? It goes to something that will come up, and we addressed the last time, Judge, your question on alibi defense, which is a question that the court has to ask. Well, how can we talk about an alibi defense when we didn't even know when most of this stuff happened? Certainly the events that have taken place on the ground. I will tell you categorically that for the better part of 1999 and a large part of 1998, my client was outside the country. But how can I give you an alibi defense without this information? It's impossible. So while we welcome as much information as we can possibly get, when you are going into a case like this and you get a list of witnesses and 37% of the witnesses that you get, you have virtually no information about, there is a serious problem moving forward. Now, is that going to be clarified in this pretrial brief or the 109 chart? Not if they're going to continue to be unidentified, or there's no way we can conduct our investigation yet further. So it's a serious problem. The way this entire matter has been structured by the SPO is a serious problem. Lack of redaction, lack of information. I mean, they gave me a forensic statement with regard to somebody where the individual who has been dead for 20 years, whose name is redacted. Now, I don't think that person's in danger anymore. I may be crazy, but the person has been dead for over 20 years, and his name is redacted for security purposes on some idea that it may be traced back to some other person at some other time who might be put in danger. I understand the analysis, but there has to be a limit to this, and there has to be a freeing up of this redacted information. And getting information on 122 witnesses on this witness list 30 days before trial is completely unworkable. Completely unworkable and prejudicial to the defense. While the prosecution comes in and says everybody's working very hard, we've got competing work streams, and they were supposed to go to trial 6 months ago. So I know that I'm overlapping with some of the comments I made to Your Honor before, and Your Honor's being quite patient about it, but you understand the difficulty from the defense point of view when you get a list of witnesses like that. I mean, I can deal with the dead guys, but, people who are kind of come in here, and present testimony about which we have no information and can conduct no interviews, and our investigation is severely limited as a consequence of that. Thank you.
Thank you, Mr. Kiu. Mr. Emerson, please.
May I start by welcoming Mr. Quick for the first time in court, making oral submissions. Perhaps the change is because Ms. Lawson is tired of making the same excuses over and over and over again. It was hard not to be moved by the pathos of Mr. Quick's submissions, that the overworked and understaffed prosecution can't do their job properly because they've got too much to do. Resources are never a legitimate justification for keeping people in custody. It's an elementary principle of international law recognised by the European Court of Human Rights that the lack of resources on the part of the prosecution can never justify a prolonged detention in pre-trial proceedings. There's a direct correlation between the obvious mismanagement, we don't need to nudge around the edges. Any professional prosecutor would have planned all this before they started the process. They certainly wouldn't have misled us all and misled you about timing and be coming here now saying, we've all got too much to do. What on earth do they think prosecuting an international criminal case was? If they haven't got enough resources, tough. It's never, ever an excuse to come to a court and say, oh dear, we've got too much to do, so we just have to have the trial put off and put off. But you know now this trial won't be beginning before 2023, effectively. It was promised to begin June this year. All of that is down to Jack Smith. All of it. He's the prosecutor. Ms. Lawson's inability to acknowledge the situation, her complete lack of any kind of remorse, her totally unprofessional and unrealistic refusal to acknowledge the situation, that the prosecution is utterly out of control and so far wide of its own deadlines that it's perfectly apparent to everyone inside this courtroom and out that they are beyond, at this stage, any serious. There's no one, the lights are on, but there's no one home. There's no one at the driving wheel. It's just careering all over the place. And introducing Mr. Quick to give the same old excuses in a different voice isn't going to help anybody. How are these defendants supposed to listen to that man standing up there saying how sad and difficult it is for the prosecution because they've got to do their job? If that was if the resources were needed, it was their job to get them before they arrested people. And you'll find all the jurisprudence in Article 6 makes it very, very clear that resources can never be a justification for unreasonable delay. We know this is unreasonable delay because we are going to be at least a year and a half beyond the date that the prosecution said the trial could be ready. So that was what they thought was reasonable. We're well into unreasonable delay territory. And so you're faced with an Article 6 issue here. You can't continue to keep these men in custody and not sanction a prosecution which is acting in violation of Article 6 of the European Convention on Human Rights, which it clearly is, because we're at least a year and a half, because of their own lack of management planning, their own disgraceful lack of professionalism. And that's what it is, and I'm not apologising for saying that. I'm very sorry that Mr. Dawson doesn't like my tone, but, you know, a little contrition, a little humility from a prosecution that has obviously gone so badly out of control and been so badly mismanaged. She hasn't once stood up and said, you know, we are sorry, actually. We did say it would be June. We did accuse the defence of misleading you by saying it couldn't possibly happen until next year. We did make all those accusations. We're sorry. We misjudged our situation. There have been large problems in the working of the SPO that we hadn't anticipated. That is a failure of management. All of those things, any responsible prosecutor would have said in public to you, to us, and to the accused. But the complete inability of the prosecution to confront reality and the idea of changing faces to make the same old excuses, this whole litigation is a disgrace. Maybe that's hyperbole from those who speak in the language of the unemotional automaton. But it's true, you know it's true, everyone here knows it's true, and above all, the accused know it's true, and everyone watching in the outside world, not just the international criminal law community, but the man and woman in the street in Kosovo. You're supposed to be one of their courts. You belong to them, and they're watching this happen. I mean, seriously, we're now having a new person stand up and say, I'm so sorry, but we've got too much to do. And we've got so many grounds of appeal to respond to. And oh, blimey, we didn't have any idea. I mean, a planning prosecutor has all that in mind. This is their big case. You know, this is the one, they call it the big case in the SPO. That's the name for it, right? It's the big case, not because there's any evidence against the accused. It's the big case because they got the 4 big fish that they want to get. And as I say, they arrested them with no idea what the case was going to be, and they still have no idea. That's why they can't draft their pre-trial brief. Why couldn't we have it on the 31st of October? They know what their case is. Why couldn't we? Why the 17th of December, curiously, the last working day before Christmas? So they can say, oh, we filed our pre-trial brief in 2022, but without the detail that should go with it. You know that because they're trying to put off the 109, which should be directly part of the brief, that information. They're trying to put that off until the end of January. So what we're going to get is some, excuse my French, but some half-assed pre-trial brief, which is as vague and general and frankly meaningless as the indictment and the documents that were put before you at the beginning of the case. Very general, promises of evidence, but nothing specific till the 28th of January. And yet, if they know their case, it can go into the pre-trial brief. If they don't know their case, what on earth are we doing here? So you didn't respond to my oral or my written request for an order for the 31st of October, other than to say that the issue would be dealt with at this hearing. The Salimi defence has made a very reasoned application for the order to be the 26th of November, and that way we'll have some idea at the December status conference of the state that the prosecution case is in. You'll be able to see if there is a case, actually. You'll be able to take that into account when you're doing your detention review to decide whether these men should stay in custody over Christmas on the basis of a case that doesn't exist. You can't have this material being served 2 days after the last status conference and far too late for any possible detention review. I mean, this is running out of control. And I mean, if there were a pre-trial chamber, you'd have colleagues to consult. But unfortunately, the responsibility rests on your shoulders. And as for the witness list, I have one thing to say. And it goes back to the point that I made earlier on about the difference between a pre-trial chamber and a pre-trial judge, or rather the sameness of the responsibility despite the difference of the constitution. It is, with respect, your job to hand this case over in a triable form to the trial chamber, not leave it to the trial chamber to knock it into shape. I'm just going to give you some statistics, and perhaps this time round we won't get the sort of, oh, it's different because we're so efficient and we're going to be so much quicker than the other tribunals. That was their position, if you remember, when we first arrived. We're much quicker than the other tribunals, that we've been set up to be super efficient. Yes, Mr. Smith, I notice he never comes into court to defend his own mismanagement. But let me give you some statistics again, as I did last time, as to how long it would take before the case was ready for trial. Let me give you now some statistics about the relationship between witnesses and trial length. Based on experience, the Popovich trial, which had almost exactly the same number of witnesses for the prosecution, 328, took 3 years, 9 months, and 20 days. The Milutinovich trial, which had 242, took 2 years, 7 months, and 10 days. And the Perlich case, which had 320, took 7 years and a month. You cannot responsibly hand a case like that to the trial chamber and have properly discharged your functions. And therefore, I'm going to ask you now to make an order, you can date it for whatever date you like, that the prosecution justify the relevance of every single witness before they are included in the case that is remitted to the trial chamber. That by, let us say, well, they should be able to do it by the 28th of January, but let's just give, and we know that they've got boo-hoo problems with the resources, so let's say 28th of March. By the 28th of March, let them justify their 328, explain exactly how they prove the guilt of these accused. Because you're going to be shocked, because I'm shocked at what they've served. It's dross. Absolute dross in terms of evidential value. So I'm going to invite you to set a date by which the prosecution, which is, I mean, unquestionably mismanaged and out of control, you're the only person who can put any control on it now. And so I'm going to ask you to force them to explain and justify every single witness, because otherwise we're looking at a 4-year trial. Let's just think about this. They're viciously resisting provisional release. The men have been in custody a year. They didn't serve their evidence until the last minute, 80% of it in the last couple of months. They still aren't ready to tell us what their case is in a pre-trial brief. And they're also, when they do serve their pre-trial brief, they're reserving the right to put the real information we need into the schedule at the end of January. So, I mean, you don't need to be a genius or a doctor to diagnose that the patient is suffering from a very serious illness. And so, you know, it's time, I'm afraid, for the surgeon, and that's you, to cut some of this crap out, excuse my French, but there is no way that you should be letting a trial go forward with a huge number of, I mean, I gave you the example in closed session of a witness who could not be less relevant. And the way it works in international criminal tribunals is in...
Mr. Emerson, I'm sorry, but it's 6:13.
I'm sorry it's 6:30 as well, but we are... this is a status conference. It's our job
I know, but I also want to listen to your colleagues. So we have to end this hearing at 6:30. So if we can have a chance to listen to them, I will have to ask you to be very brief to finish.
I'll sit down, but the point this is a formal application to you to give consideration to the appropriate date, but to make an order timiously, first of all, that the prosecution, as the Salimi defence have proposed, serve their pre-trial brief on the 26th of November. So we have 2 weeks to digest it before we come in front of you again on the 15th, and we can discuss just how sick this patient is. And that you also issue them an order. It should be the 28th of January or near thereafter, because they should have known by then, justifying why each one of those witnesses needs to be called viva voce, because most trial chambers or pre-trial chambers would be looking at this and thinking that number of witnesses needs to be cut by 2/3.
Thank you, Mr. Emerson. Mr. Roberts, please.
Fortunately, Your Honour, I have very little to add to what's already been put across, so hopefully we still have time. My submissions are set out in writing. I think they're entirely reasonable. I think there are good reasons which have been expounded upon in more detail by my colleagues as to why we need this before the next status conference. Otherwise, it's going to be the end of January before we're discussing anything, and any problems we have then get pushed further and further down the line. And obviously, I don't need to echo my colleagues' concerns about the length of detention that all of the accused have been suffering and will have been suffering by that point. The only other thing I would like to add, and this relates to the disclosure of the chart, is that we did actually suggest the categorization early on so that they would be helped in that process. With the prosecution having to categorize their evidence through legal workflow, they should have been able to understand what each piece of evidence related to, and had they actually followed all of our requests, they may well be in a better shape to complete their pre-trial brief on time than they claim to be. So I don't want to say I told you so, but that's clearly what I'm saying. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, please.
Your Honour, it was filing 00097, paragraph 14. The SPO submits that trial in this matter should commence this summer or no later than September 2021. When the prosecution come here today and say they can't possibly prepare the pre-trial brief any earlier than 17th of December and they need longer for the chart, I always have to come back to this filing, the position that was put before you at that time. How could that possibly be a true and genuinely made submission if they are unable to produce these documents any earlier? We agree with the submissions that have already been made by the other defence teams, and we support them. We would say, from a practical point of view, not the last day before the recess. It only takes something small to slip for there to be an issue with workflow, and we'll be left without the document for even longer. So we fully support the date set by the Salimi defence and the reasons given for it.
Thank you, Mr. Ellis. Mr. Prosecutor, briefly, please.
Yes, Your Honor, thank you. Just a couple of things. As for estimates being provided previously, they were provided in light of the circumstances existing at the time and the available information. It is inherent in the nature of things and proceedings like this that those circumstances may change, and there have been a number of circumstances in this case which have necessitated changes. What we are telling the court is that we are actively progressing all of the work streams necessary to a pretrial process. There are multiple coexisting work streams which must, as part of the regular pretrial process, be completed before the case is ready for trial. Each of those matters are continuing to be expeditiously progressed in parallel to one another. The Thaci and Vaselli defense appear to misunderstand the nature of the Rule 109C chart and of the pretrial brief. The pretrial brief will obviously have footnotes to the SPO's evidence. However, in addition to those footnotes, and in addition to the subcategorization and legal workflow, the SPO is being required to also provide this Rule 109C chart. As for the relevance of the witnesses, that is the purpose of the final Rule 95-4 materials, including the final witness list, the final pretrial brief, and the Rule 109C charts. Thank you, Your Honor.
Thank you. Mr. Q,
Just a
very,
brief
very
comment.
briefly.
Just very brief, Judge. I mean, the SPO is not being required to do anything. The rule tells them to do it. This is not something that's being imposed unjustly by someone on high. The rule says they're supposed to do it, and they have not successfully or explained why they can't give it to us when they give us the pretrial brief. I mean, most of the charges that they have here this is a cut and paste indictment for charges that were litigated in other places like the ICTY, represented by my learned colleague to the left, where people were acquitted. And now we're seeing it all again here. The same stuff. The same incidents, the same witnesses, I suspect. So, are we re-evaluating? Are they recooking that egg? Are they doing that all over again? I suspect not. The arguments given as to why this takes so long, and the work streams, given the fact that they're just taking these other charges and then slapping it together in this indictment, is just a specious argument. With all due respect, Judge, thank you.
Thank you, Mr. Kihu. Madam Prosecutor, very, very briefly, then you have like a 20
I will be
seconds.
extremely brief because my colleague and our written submissions have already covered the substance. However, Mr. Emerson's repeated personalised comments directed at individual members of the office, whether it be me, my colleague, or the specialist prosecutor, do not advance the submissions being made. They are entirely gratuitous and they fall far short of the conduct required from counsel.
I'm not going to accept this, and it's disgraceful to do it. Every single time Miss Lawson stands up, she criticises me, and yet she can't take the slightest criticism of her own conduct. Oversensitive snowflake, sitting there, responding with absolute total lack of any compassion and total equanimity to the continued detention of these accused. But above all, I do make an allegation against Mr. Black. He's out of control. He hasn't planned this prosecution. It's no good saying, oh, the estimates were made on the basis of things as they seemed at the time. Come off it. We were all saying, if you were involved or read the transcripts, you know this. We were all saying those estimates are completely unrealistic. You need to build in the capacity for what is really going to happen. And now you're sitting here asking this judge to give you indefinite extensions that are going to force this trial into 2023. If you don't like personal criticism, then start acting professionally.
Let's move to the next topic in the agenda, which is the defense investigations. I would just like to hear if any of the defense team would like to give any update on its investigations. Mr. Kihu.
I mean, yes, certainly, Judge. We will tell you that we have all of these documents that continuously come over the transom on a daily basis. As I said to Your Honor, 17% of them came from since the last status conference. You're finding out where they're going in. Folks are deployed trying to figure out what these witnesses are talking about because there is not a consistent numbering system within the documents. It's an inordinate amount of time to try to do that. With regard to the investigation on the ground, putting aside any COVID issues, obviously that without a pretrial brief and seeing what's the government's position on these charges and what are they actually alleging, I'm not saying that we're not investigating down there, but in the interest of speed and efficiency, and I know this comes at a cost, a financial cost, we have to know what they're actually alleging in order to focus that investigation, and we have not been able to do that. I'm not saying that I'm not going to mislead the court and say we're not doing anything, but I trust Your Honor understands that a focus that comes when we're saying this is what our allegation is, and until we have that, we certainly can't give you a fulsome response to that. Now, I will say, as I said previously, at the risk of repeating myself and what I said the last time, with regard to the alibi defense, it's just impossible at this point. We can revisit that down the line, and I'm sure we will, but we don't have an answer to that now.
Thank you, Mr. Kihu. Mr. Emerson?
We have established a defence investigation office in Pristina. We have a team set up led by a senior solicitor. And we have a number of investigators just waiting to find out what the case is. So they're on the payroll but they don't know what they're supposed to be investigating, because we haven't received any meaningful case from the prosecution whatsoever. I want to make one thing clear. As counsel, I take responsibility for my team, and you're perfectly entitled to ask me, what are you doing and how are you progressing this? I would just like to see some personal responsibility being taken on the other side of the courtroom. And as far as we're concerned, we're in the situation where doing the very best we can, and even without all of the material which is going to the 68,000 documents, which we are going to have to request one way or another. You know, I've done it in a generic way, but if we don't do it in a generic way, we'll make the requests sequentially for the lot of them now, because they're all potentially relevant to this waffle case. We need the same pool. So, it's impossible. How long is a piece of string? I can give you a pretty good certainty that since we can't start investigating till January at the earliest, possibly not even until after the 28th of January when we see the actual connections, because I suspect their pre-trial brief will not contain the information it needs to contain, otherwise they would serve them simultaneously. They're trying to buy some extra time to clarify their case. But let's say we get started in the midst of winter, just after January. The best estimate I can give you is that we'd be looking realistically at a trial in January, February of 2023.
Thank you, Mr. Emerson. Mr. Roberts, please.
Nothing to add, Your Honour. We're all obviously very much in the same boat. We haven't progressed much further than we had before. We're trying our best. We are obviously stymied in the same way as every other defence team by the lack of knowing what the specific allegations are. So there's nothing I can particularly assist you with at this point. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, please.
Yes, Your Honour, we're in the same position. We're in the same position. We adopt what others have said, Your Honour.
Thank you, Mr. Ellis. I confirm to the parties that the next status conference will be held on the 15th of December at 14:30 Hague time. This is what I already mentioned in the previous status conference. At this point, I would like to ask the parties if they have any other issues they would like to raise, starting with the registry. Maybe are you in a position to give details about the question that we had about translation? Mr. Roche.
Thank you, Your Honour. Yes, the unrevised translation of document 5548 will be distributed after 1600 hours on Monday. Thank you.
Given the timing.
Mr. Emerson, please.
Oh, sorry.
I give you the floor. So you have the floor, but...
Okay. So I was just responding immediately to that. So since we have a timetable of Monday to file, we will file the unofficial translated version that we're using. But of course, by the time Your Honour considers it, the two will be together. I have been asked if it would be possible, and I know this would normally be done in writing, but if I could ask, given the way the matter has been put by the SPO and the fact that Ms. Lawson hasn't withdrawn the imputation of impropriety, we are going to have to deal with that, and that requires some extra words. So could I ask you to grant us an extension for the reply?
How many words?
Can I ask Mr. Strong, who is primarily responsible, to give me the number?
Yes, I think an additional 1,500 words should suffice.
Then I will issue a first oral order, and I will grant the request from the defense for an extra 1,500 words for their reply. This concludes my first oral order. Madam Prosecutor.
Just to respond to the Vaseli defence's last point, it is not an allegation of impropriety that we're making. It's an indicator that the Vaseli defense...
Madam Prosecutor, you said that this was going to be dealt with in writing. So it's going to be dealt with in writing between the parties. But we're not going to raise this now. It's 6:28. So please, do you have any other matter you would like to raise apart from this? You cannot ask Mr. Emerson not to raise this kind of issue in the status conference and then raise them yourself. So please, do you have any other matter you'd like to raise?
No further matters. Thank you, Your Honour.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor. I obviously have the issue of interim release. We had an adverse ruling from the appellate chamber day before yesterday, but as far as Your Honor is concerned, and I ask this in moving ahead with some of the questions that Your Honor has asked, can you give us some guidance as to what path we should follow for pretrial release? Given all of these delays, et cetera, there is a police report that Your Honor has ordered that is going to come to the fore, that is being translated as we speak. But any guidance that Your Honor can give us on that score would be extremely helpful, given the time that these gentlemen have been, my client has been incarcerated, and it looks like there's going to be a significant period of time before this case goes to trial. I know it's late. I know that's a lot to put on the table, Judge, but it's an extremely important issue. We've been talking about basically all afternoon.
Guidance regarding the deadline for your submissions?
No, what is it sufficient? I mean, sufficiency seems to be the issue.
Exactly as I said to Ms. Lawson, this is not in agenda. We're not talking about this matter. This is done via written ruling, so you can make a request. You can include this in your submissions, but this is not in the agenda. I repeat exactly what I said to the prosecution.
And it was under the table of other issues, Judge, and I wanted to raise it and bring it to Your Honor's attention because it's something that's obviously seriously concerning my client and the defense team as a whole.
Thank you, Mr. Kihu. Mr. Emerson. Thank you, Mr. Emerson. Mr. Roberts, please.
Nothing to add, Your Honor. Thank you.
Thank you, Mr. Roberts. Mr. Ellis, please.
Thank you, Your Honor. Nothing further.
Thank you, Mr. Ellis. Mr. Laws, please.
Well, thank you. Just one matter. It relates back to the working forum in relation to legal workflow and the establishment of legal entities. Just to put on the record that we would welcome being included in that working forum, please. Thank you.
Thank you, Mr. Laws. This is noted. Before we end this hearing, I will issue a couple of oral orders. I already issued the first oral order, so I will issue my second oral order concerning the SPO's pretrial brief and related material according to Rule 95 4A to C. In light of the parties' submissions and considering that we are nearing the completion of the disclosure of Rule 1021B material, I order the SPO to file its pretrial brief and related material pursuant to Rule 95 4A to C of the rules by 17 December 2021. I further order the SPO to file its Rule 109C chart by 28 January 2022. This concludes my second oral order. I will issue my third oral order concerning the SPO's deadline related to Rule 1021B material. I note in this regard that I will issue a decision on the SPO's 11th and 12th requests for protective measures after the 1st November deadline for the disclosure of Rule 1021B. I further note that the SPO has indicated that the following Rule 1021B material is outstanding. One associated exhibit of an international witness for which Rule 107 clearance was denied, lesser or unredacted versions of transcripts and associated exhibits of 3 witnesses, and prior statements and associated exhibits for 2 witnesses subject to variation of protective measure requests. Given the SPO's efforts to receive clearance for these remaining materials and its attempt to improve the efficiency of the translation process, I consider that good cause has been shown for the requested variation of the Rule 1021B deadline. The current Rule 1021B deadline for the outstanding material, including material pending protective measures request, is therefore varied, and the SPO is ordered to disclose such material to the defense as soon as possible and on a rolling basis, but no later than 31st January 2021. As regard translation of Rule 1021B material, I order the SPO to provide outstanding translations as soon as possible and on a rolling basis, but no later than 31st of January 2021. This concludes my third oral order. I will now issue my fourth oral order concerning deadlines in relation to Rule 1023 material. In light of the parties' submissions today, I suspend the defense deadline to request the Rule 1023 material. The current suspension for SPO deadlines in relation to Rule 1023 material remains. In the meantime, before deadlines are re-established, the parties are expected to continue expeditiously towards the disclosure of Rule 1023 material. This includes the defense requesting items material to its preparation from the SPO's amended Rule 1023 notice and the SPO processing these requests. Deadline will be re-established at the next status conference unless otherwise ordered. This concludes my fourth oral order, and I can already indicate to the parties that we will continue the discussion on this material following the arguments raised by the defense today at the next status conference. I will now issue my fifth oral order on the defense for Mr. Selimi's request concerning Rule 1023 material. In its submission of 27 October 2021, the defense for Mr. Selimi requested that all items on the SPO's Rule 1023 notice be disclosed without assessment the materiality of the items. I note that Rule 1023 of the rules only obligates disclosure upon showing of materiality on the part of the defense. This is due to the nature of this category of material and contrasts with the mandatory nature of disclosure in relation to supporting material to the indictment and material that the SPO intends to rely at trial. I therefore find that disclosure of all items on the Rule 1023 notice need to follow the process stipulated in the rules. The defense from Mr. Selimi's request on that point is accordingly rejected. This concludes my fifth oral order. I will now issue my sixth oral order on the defense for Mr. Selimi's request for further categorization, linkage, and review of disclosed material. In its submission of 27 October 2021, the defense for Mr. Selimi requested that translations, revised or lesser redacted versions, or documents with corrected metadata be linked in legal workflow to their original documents. That all documents linked to Mr. Selimi being reviewed again by the SPO, and witness entities be created for all witnesses on the SPO's preliminary witness list, and relations be created in legal workflow between all statements and or documents relating to a particular witness. In order to facilitate defense processing of disclosed material, I order the SPO by 15 December 2021 to create witness entities in legal workflow to link statements or documents to the relevant witness. Finally, I invite the SPO and the defense for Mr. Selimi and all other defense teams where applicable to engage in inter partes discussions to review all documents categorized as linked to Mr. Selimi and review whether translations, lesser redacted versions, and corrected versions of documents are properly linked to their original in legal workflow. I invite the parties to report to me on this issue in their submissions before the next status conference. And this concludes my 6th oral order. And I inform the parties that this is also going to be an item to be discussed at the next status conference. This concludes today's hearing. I thank the parties and participants for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. And I just inform Mr. Kihu that I will order the redactions of one sentence you mentioned just before during your last intervention, because it was mentioned things that were not in the public domain yet, relating to some countries that you raised a little earlier. Yes, sir. Thank you. This hearing is adjourned. Thank you.
All rise.